Okay, great. Okay, so welcome everyone. This is the public hearing on warrant articles 17 and 25 by the Advisory Committee's ad hoc subcommittee on warrant articles 17 and 25. This subcommittee is essentially a joint committee of the Advisory Committee's Public Safety and Human Services subcommittees. I'm Susan Granoff, its chair. The other subcommittee members present, I will identify, and if you could just wave so people will know who you are. David Mark Goldstein, Donnell O'Neill, Fran Perler, Jocelyn Murphy, Neil Gordon. Let's see who else is here. I don't think any of the others are here. I'll just list some of the other names. Some people are running a bit late. Elisa Jonas.
Liz Linder is here.
What?
Liz Linder is here. She's
Oh, good. Liz Linder is here. She's a member. I was just about to read her name. And Perry Grossman is running a bit late, and Janice Khan is unable to attend. So that is the subcommittee. And on behalf of the subcommittee, I'd like to welcome all of the members of the public who are here and all of the town staff who have taken time out to be here. We very much appreciate your attendance here. And a few words about this, how this hearing is going to be run. The first part of the public hearing will focus only on warrant article 17. It will begin with the 5 to 7 minute presentation by the petitioners. Then I'll ask Police Chief Pastor and Associate Town Council Susan Harris and Chief Sullivan if he would like to make some comments about this particular warrant article, to make statements specifically about any concerns they might have with this particular warrant article. About 5 minutes, a summary of anything that you may have put into a written statement that has been sent to our subcommittee members. And then we'll open up the public hearing for comments from the public, and any petitioners who didn't have an opportunity to speak during the presentation could also make a brief statement at that time. Next, the subcommittee members will have an opportunity to question the petitioners and town staff about any aspects of this warrant article, and to make, at some point, to come up, if they choose, with any amendments or recommendations. And then we will go through the same process for warrant article 25. My thinking at this time is that we're going to hold off taking a final vote on either of these articles until near the end of the meeting, just in case something comes up during the discussion of 25 that might cause us to reconsider any portion of warrant article 17. So that is the procedure. But before beginning, we need to take a vote, since this is the first time that our subcommittee is meeting, to take a vote concerning minutes. And the motion that I'd like to put before us is to authorize the ad hoc subcommittee chair to approve on behalf of the subcommittee the minutes of the subcommittee's hearings and meetings pursuant to the open meeting law.
So moved.
Is there a second?
I'll second it.
Okay.
And it should be the joint ad hoc committee. So you can
Yes, it's not, the name of the subcommittee is the joint, is not the joint it's the ad hoc committee on warrant articles, ad hoc subcommittee on warrant articles 17 and 25. I just said it was a joint because that's how the members were chosen, but that's not the title.
Let's just get to the vote and get on.
Yeah. This has to be a roll call vote. David Mark.
Yes.
Perry is not here, right? Donnell.
Yes.
Fran.
Yes.
Jocelyn.
Yes.
Okay, Neil. Neil Gordon.
I'm a yes.
Great. Liz Linder.
Yes.
And the chair votes yes. Is there anyone else who has, Alyssa? This is a vote simply to have
Yep,
the.
I got it. I have it. I was on.
Oh, you were, okay. And what is your vote?
Yes.
Okay.
Perry just arrived.
Who did?
Perry is coming in now.
Okay.
Yeah, be careful. Anybody votes no, you'll be assigned writing the minutes.
Okay.
I would gladly give up that role.
Okay, Perry, do you want to just take part in the vote?
I'm sorry.
It's just a vote to allow the subcommittee chair to approve the minutes going forward.
Sure, yes.
Okay. All right. So it's 1, 2, 3, 4, 5. 9 to 0 to 0. Okay. Oh, now Alec, I'm sorry.
Am I a member of the subcommittee? I'm
You-
the petitioner.
It's
so-
very odd. You were technically put on it, but you are participating strictly in your capacity as the petitioner. However, if you'd like to vote on this matter, since it doesn't involve the warrant articles per se.
I'll vote yes then on this.
Okay. Yes, it was sort of odd, but anyway, thank you very much. Okay, moving on. Chi-Chi, do you have a presentation, and you've been made a co-host, correct?
I have a presentation. I've been made a co-host, so I am going
Great.
to share my screen.
Great, and about 5 to 7 minutes would be the appropriate amount of time. We'll of course be following up with questions.
Sure. This I
Oh,
think was
could
about 7 minutes.
Before you start, could I just clarify the amended version that you sent out to us? Is that now considered the version of the petitioners that we are supposed to be focused and discussing at this public hearing?
So those are amendments that we are contemplating making. I think procedurally, we don't need to determine the final until like right before town meeting. You guys can bring your own motion should you so choose.
I don't want to
The-
waste our time discussing
reason-
something that won't actually be there and not discuss something that might be there,
So, yeah, let me finish. The reason I'm not saying it's final is because select board may have additional requested edits. I have gotten feedback from select board.
Mhm.
There are a few other things that they're concerned about. So I can't say it's going to be final.
We're
but
not
the-
asking that.
Yeah, so this is
The
a
only
change.
question I want to ask is, as of this moment, is this the best version of this is what you have added to it, or changes you've made since the select board, taking into account their recommendations? And is this now the version that, as of the moment, is what, is the current best version of it?
Yes, yes.
With the understanding there may be additional changes later.
Yes.
Okay, thank
Yes.
you. That's all I wanted to clarify.
Okay. All right. Understood. It's been a little bit of a shifting target, but only because we want to get this right.
Right, no, I understand.
So my name's Chi-Chi Wu, town meeting member in precinct 7 and co-petitioner on warrant articles 17 and 25. I'll be talking about 17. I want to acknowledge my co-petitioners here today, Alec Lebowitz and Jessica Kiko will be talking about 25, Marissa Boat, who's on, and Amy Newell and Scott Nadian, who couldn't join us today. Warrant Article 17 basically establishes a prohibition on ICE enforcement on town property. So some background. I think most of us are aware about the horrifying actions by and abuses by Immigration and Customs Enforcement nationally. ICE has, detained Many immigrants, many of them here legally with green cards or visas or asylum seekers, most of whom don't have a criminal record, has abused a lot of them, has even detained and abused citizens, detained children. The conditions in the detention centers are terrible. In Minnesota, Chicago, and Portland, they've terrorized entire cities with their surges, and they've killed 2 innocent people, Alex Preddy and Renee Good, and then, blame them for being terrorists. In Massachusetts, we have not seen a surge, but there have been numerous examples of ICE detainment, including, an 18-year-old illegally detained, a Babson student who was detained despite a court order, and then a Tufts PhD student who was detained simply based on her First Amendment activities. And of course, we are concerned about a surge in the Boston area, given that the Trump administration likes to target blue cities like Boston. Brookline would have an enormous stake if there was such a surge, because we have a high percentage of immigrants. 1/3 of our residents are immigrants. I count myself among them. And that's the second highest percentage in the state after Everett, Massachusetts, according to the Brookline Community Foundation. In Massachusetts, we have responded to the ICE abuses. We've not taken it lying down. The governor has signed an executive order about no ICE enforcement on state property. There are similar executive orders and prohibitions in a number of other cities in the region. And then, of course, our select board passed a proclamation on February 10th, 2026, concerning ICE activities, federal civil immigration enforcement being prohibited on town property. And we are very grateful for that, and commend that. So in listening to the passage of that proclamation, one of the things we noted was that there was discussion about how it would be enforced, and someone said, well, we would go to court to enforce this ordinance. And we thought, well, the proclamation is not an ordinance, but a bylaw is an ordinance. And so we thought it would be good to have the proclamation codified as a bylaw in the town bylaws. So the original version of the article had 2 paragraphs, which were basically lifted from the proclamation, almost word for word. The first paragraph, we included example of police stations as an example of a town facility, but obviously it would be assumed in the proclamation that because a police station is a town facility, and basically prohibiting the use of town facilities for immigration staging or operations base. Now we did get a comment from the select board about adding the word federal in front of civil immigration just to make it consistent. We're happy to do that. Moderator said that's in scope. The second paragraph, again, was originally lifted from the proclamation. Town council did express concerns about the second sentence in the paragraph, prohibiting, limiting access to the public areas of public buildings, raising some issues potentially under the supremacy clause. There was a suggestion to model language instead on what is in Cambridge and Somerville's executive order. So we did that. We changed the second sentence to be closer to what Cambridge and Somerville did. Also, select board expressed a concern that the first sentence focused on specific individuals, i.e. civil immigration enforcement officials, and prohibiting them from non-public spaces of public buildings in the absence of a judicial warrant or court order. So we took that from the proclamation, but happy to change that to the activity of civil immigration enforcement. So those are changes that we're willing to make. And then we had a conversation with the police department that they were concerned about that this would be in the bylaws, and down the lines years later there might be an officer who only saw the bylaws, didn't see the proclamation and the discussion in the proclamation about how this is enforced. That's supposed to be enforced by the town administrator going to court, and to respond to that, we were willing to put in paragraph 3 of the proclamation. However, the moderators thought that certain provisions of paragraph 3 weren't appropriate for a bylaw. So instead of saying the town will document violations of this bylaw, notify the town administrator, and the town administrator is authorized to go to court to seek an injunction, it says violation shall be considered civil in nature only, so it won't be a criminal offense or a misdemeanor, because there were concerns expressed about that. And then instead of saying, and in the absence of a duty to intervene pursuant to a general order, it just says pursuant to policies approved by the select board. And then the rest is sworn officers will not interfere with immigration and law enforcement operations in progress. So again, the reason to bring a bylaw is that to increase the ability to enforce it, to make it codified and law. If you look at the documents that various stakeholders have sent, such as the police department, you'll notice that, there is acknowledgement. There's a difference between the proclamation and bylaw, and the bylaw is more enforceable. Also, by putting it in our bylaws, we hope that we will always be opposed to abuses by ICE and always, prohibit civil immigration enforcement on town property or prohibit staging activities, etc. But if things should change, we think that town meeting should have a say if a change or a reversal is sought. Thank you.
Susan, you're muted. And,
Yeah. I was following my own advice about that. Okay. And at this point, we'd like to ask Chief Pastor, do you have a 5-minute summary of concerns? Have you had an opportunity to look at the amended version that we sent to you? So we would very much like you to comment on the latest version and whether there are any modifications of your concerns because of these changes.
Thank you. Thank you all. And I think when we drafted this executive order, I worked alongside town council and the town administrator to come up with an executive order that we were all comfortable with. I'm glad that the warrant article rather, does reflect a lot of the language and shows the common ground that we all have. Really, the piece that I'm stuck on is the enforcement piece, and I do appreciate the modifications that were made to try to address that. I truly do. I just think in an attempt to clarify, it just doesn't do enough because, towards the end of the bylaw book, and, I'm probably speaking to the smallest group of people who has actually read all of the town bylaws from cover to cover, which I appreciate that. But you'll find that, the police department ultimately is responsible for all of the bylaws contained in that book. And furthermore, there's mass general law that says, it's a willful violation of a town bylaw is arrestable, and that's a police power as well. So I think it gets, I think we're muddying waters, and I think we're chartering into some a territory that I'm not comfortable with when we start taking one bylaw and saying that we don't intend for the police to enforce this particular bylaw and having it be the only one in the entire manual. I agree with the spirit of what's being proposed, and I think that there's a lot of things in here that we do share as common ground, but it really comes down to public expectations, now and in the future, and what the law tells us to do with regard to bylaw enforcement of all kinds. I don't think we can pick apart, cherry pick which ones will be enforced by the police department.
Okay. Does town council, Susan Harris, perhaps, who did the opinion on Warrant Article 17, want to weigh in on that? And in particular, I'd like to call your attention to Article 10.3 of the bylaws, which deals with how violations are characterized. in this particular section and in other sections of the bylaws of the town?
Hi, thank you. I can walk through a little bit the opinion that I gave previously in terms of the original language, and then talk a little bit about the amendments. At the beginning of this warrant article talks about a prohibition on staging. In our view, that that's a relatively narrow limit that we feel is legal because federal authorities are prohibited from commandeering state or local resources, and that prohibition really mirrors what's in the state's executive order. Where the warrant article goes on to talk about accessing non-public areas of public buildings without consent. Again, that sort of codifies existing law and the town's existing position from the proclamation that ICE or anyone can't go into a private space without a valid judicial warrant or court order. Where we suggested some alternative language is where the warrant article goes on to talk about access to public buildings more generally, and our concern was that would be read to be limiting access to public buildings in a way that might go too far. Under the Supremacy Clause, we can't directly regulate or discriminate against federal authorities. So if someone else is allowed into a public space, immigration officials are allowed there too. Excuse me. So we suggested recharacterizing that as more of a policy statement than an enforceable restriction, and that's consistent with what some other towns have done. I took a look at the proposed amendments. I don't have much additional to flag there. I think with respect to adding the word federal in paragraph 1, I think it was added there, but maybe not in part of the amendment to paragraph 2. So maybe just double checking that. Overall, I mean, immigration regulation is reserved to the federal government anyway, so I'm not sure it makes a big difference, but I agree consistency is helpful there. As to the enforcement piece, I think that's, the amendments clarify that this would be treated as a civil violation.
Mm-hmm.
I do think, the question of, how that impacts the police department or expectations around how the police department would be handling violations is probably a policy question. But here the amendment does state specifically that it would be treated as a civil matter.
Okay, thank you. If we have any additional questions, we of course can get back to you. Does Chief Sullivan want to weigh in? I don't believe you had commented on this particular warrant article, and it may not be pertinent to your concerns.
I do not have an opinion on this article. Thank you.
Okay, thank you. Okay, so at this time, if there are any public comments that people would like to make, can you put your name into the chat room? And when you begin your comment, please identify yourself. If you're a town meeting member, please state that. If you're a member of a particular organization and you're representing them, that would be information we'd like to know. If there are other town staff members present who would like to make a comment, that please do so at this time, and you could also include your particular position with the town. And if any of the other petitioners would like to add a brief 2-minute statement at this time, that would also be permissible. So this is your opportunity to weigh in on any aspect of this warrant article. Okay, and David Mark is going to be handling the chat room. Has anyone signed up yet?
No, so handling the chat room is very easy.
Okay, I will keep it open in case someone decides to say something. So now we can turn it over to any questions that the subcommittee members may have. And because I'm writing up this particular report, I have a couple of questions or comments about the wording that I just wanted to make
Susan,
at the time.
Pardon pardon the interruption, but could you put the language up on the screen so we can see it while you're referring to it?
I can share it again if you're ready for that. We have Jocelyn and we have Perry waiting to make comments or questions.
Yeah, that,
If you're going to be talking about language.
since I'm
it would be
talking
helpful.
about the wording, I think that would be appropriate at this time. If you can do that, David Mark, that would be great.
Thank you.
Just give me a moment to pull it
Yeah.
up. All right, and let's see, share. All right, does everybody see it?
Can you make it larger? Old eyes. Perfect, thank you.
If I do that, I don't know if you'll see the whole thing, but as you can see, it's now in section 6.xx.1.
I think you can move down to section
also-
2. Yeah,
It only
because there's
has the word federal in one, so I'm gonna go all the way down.
Okay,
to
when
three.
you can keep it on top so that as I get into other parts, you could move it perhaps.
Sure.
But I actually don't have any comment on the first paragraph. The second paragraph, I think that they're definitely, I like the improvement in the first sentence. I listened to the the select board's comments, and I think that that's a definite improvement to focus, to prohibit the activity as opposed to officials using that space. It's the activity that is the focus of this specific prohibition. I have a question and concern about the second sentence from a different point of view. I agree with the concerns that have been raised by town council and by the police chief about the second sentence, but also as a litigator, I think it weakens the prohibition. I think that the first sentence is an airtight prohibition, but the second sentence, in effect, provides wiggle room for the federal government. If we have an injunctive request, they could simply argue that what they're doing is providing a specific service to members of the public, even though, it's not a service they want, but we're giving them wiggle room when in fact, the very first sentence is an airtight prohibition. I don't think that second sentence is needed, and I think it weakens the very first sentence. So my recommendation is to eliminate it because I don't think it adds anything. This whole article is supposed to be a prohibition. This whole bylaw is a prohibition. And I don't think it's needed to clarify anything because the first sentence of that paragraph says everything that needs to be said. As to the other two new sections, I think that they do serve a good purpose, but I think that some of the wording is a little vague. In section 6.3, when you say the town will document, who specifically is supposed to be doing this? Is this police officers? Is this, who is going to be required to do this? I understand one of the reasons for documenting this is that if we are going to court to request an injunction, we need to show evidence of sometimes they want to know how many times these violations have taken place. So it is important to keep a record. But I think that the word town is somewhat vague, particularly for an article, a bylaw. So I hope the petitioners can consider that further. I agree. I think that stating specifically that this is considered a civil violation is useful. But I did want to point out that there are 3 articles in the bylaws that deal with enforcement, and they are somewhat contradictory because one states that violations are considered misdemeanors. I can pull them out and just go over them. Article 10.1 specifically says that violations shall be deemed guilty of a person violating this shall be deemed guilty of a misdemeanor. Okay. But Article 3 says a violation of any provision of these bylaws may be dealt with as a non-criminal offense in accordance with the provisions of General Laws, Chapter 40, Section 21D, which provide essentially that cities and towns are authorized to handle violations of bylaws through a non-criminal ticketing process or issuance of fines, and not consider it as a criminal violation. And then, of course, as the police chief pointed out, there's an explicit statement in Article 10.2 that the provisions in, and they list 4 different parts of the bylaws, including this one, shall be enforced and violations prosecuted by any police officer of the town. So that is the enforcement language that currently exists. So my question to the petitioners is, how exactly do you envision enforcement? You make it now very clear that we do not expect police officers to intervene with the actual actions that are happening at the time that they are taking place. The new Section 6.4 says that in the absence of a duty to intervene pursuant to policies approved by the Select Board, sworn officers will not interfere with federal law enforcement operations in progress. So I can't see them handing out tickets to the federal ICE agents operating. The other thing is, I think you should be specifying, instead of saying sworn officers, you should be saying sworn police officers. In the original proclamation, there was a reference to a police order in that sentence. You've eliminated that. And so to be clear who you are referring to, I think you should add the word police between sworn and officers in Section 6.4. So those are my comments about the wording. I do think the amendments are improvements, and I'm glad to see them.
So thank you for those comments. I would say with respect to the question about how we anticipate this will be enforced, as you can see, we originally were going to include the language from the proclamation that the town administrator could seek a court order in joining the prohibited behavior. In addition to enforcement under Article 10.3, which is the civil fine authority, we wanted to leave the option because, as you know, civil violations can still be enforced via injunction. We were contemplating either the town administrator seek an injunction or a civil fine could be levied pursuant to 10.3.
Mm-hmm. Okay, but you don't necessarily have to specify that in the bylaw itself.
So, yeah, I mean, as I said, the moderator did not think the injunctive the language about seeking an injunction was inappropriate. And then we didn't want to say it was just enforced by 10.3 because we want to leave the possibility of an injunction. But, it would be civil only. And in fact, there are provisions in the bylaws apart from this in Part 10 where it discusses other members of the town officials enforcing certain parts of the bylaws. So they're not all necessarily enforced by the police department.
Yes, that's true. Okay, and what did you think about the idea for eliminating that second sentence in paragraph in 6.2?
So I would have to talk to my co-petitioners about that. There are 6 of us. We are drafting by committee. We certainly will consider and discuss it. Yeah.
Okay, and then the only other question I had is there a need to define terms that that are critical, such as the word facilities, when you say no person shall use any town facilities, and then you include, but not limited to, and you list things, is once it's a bylaw, as opposed to a proclamation, I think it's important to make it clear what is being prohibited. Because if you're taking someone to court to get injunctive relief, they can simply say, well, we had no idea that that's how facilities were being defined, or what have you.
So I believe if you look at part 6 of the bylaws, where this would be housed, there's similar language used about town property.
Okay.
I'm just trying to pull up
Is
some
there a
of it.
definition of facilities in any of them? Because you can simply refer people back to that definition. It's just a suggestion.
So, for example, the prohibition on consuming alcohol talks about no person shall drink, consume, etc., alcohol while in or upon any land owned by the town of Brookline, upon any way to which the public has access, as a right to access, or any place which members of the public have access as invitees or licensees. So I'm not saying we would use that language. I'm saying that the level of specificity seems to be similar.
I'm just saying that facilities is vaguer than land owned.
I mean,
so you might want to consider.
We'll consider, think about it.
As long as you're thinking of other amendments. That was just my concern as someone who's done some litigation. So. Okay, so I can't really see anyone's hands being raised now to call on people. Do we still need to share the screen with the document at this point, or can we?
Marty Rosenthal's hand is up.
Yeah, hold on. I was asked by Jocelyn to put this up. I'm willing to take it down if you want. It doesn't really matter to me, but I do have a list of people in queue. Do you want to handle public ones before subcommittee ones, or is it just whoever puts their name in first?
I'd like to, well, at this point, I'd like to, so are these, I had hoped that that people who are not subcommittee members would be doing it earlier.
So we have 3 subcommittee members who put their name in the chat where they're supposed to, and Marty, who put his hand up instead of putting his name in the chat.
Okay.
So you want to take Marty first?
Why don't we do that?
All right, Marty, you're up.
Oh, the volume's going?
We can hear you.
Oh, good. And unlike the select board, you got to get allowed in. Thanks. So I wanted to hear a little bit of discussion before raising my hand, and some of you may have noticed that I have some interest in these issues. And frankly, it started for me also with the proclamation. And that night I was only watching the meeting because of the Chestnut Hill discussion. And I look at the agenda and see this proclamation after that. And that's the first I knew about it.
Right.
And,
Marty, I just want to remind you, you have about 2 minutes for your comment.
Well, all right. So in other words,
you could provide us with a written statement of anything longer than the 2 minutes.
all right, well, I wasn't aware of a time limit. So may I just start again since you just made me
Sure,
aware?
go right ahead.
All right, so let me get right to the issues then. I think the biggest issue is I think there are a lot more problems than have been mentioned in the previous discussion, and especially in town council's memorandum. And I think that the fact that this is a bylaw always gets reviewed by the Attorney General, I think will jeopardize not only this particular warrant article in the bylaws, in the bylaw provisions, but also will call into question all the executive orders that have been published by at least 6 cities in Massachusetts. I think there were 5 right before this and Worcester earlier. And I sent you a long article by the Vera Institute, a well-known and not especially extreme group, maybe less extreme than the ACLU even, which is not extreme. Anyway, the point is identifying a lot of issues, and I think that it's a lot more complicated than, with all due respect to town council's office. I wish they were right that this is going to be fine, especially paragraph 1. I disagree with the chair of the subcommittee, Susan, respectfully, that paragraph 1 is going to be no problem. And if you look at paragraph 1, let me give you an example. I believe, from talking to Lieutenant Campbell a few weeks ago, that there have been 2 people detained after being released on bail from arrest at the Brookline Police Station. Now, why doesn't public property, it's not listed, include streets and sidewalks? If ICE parks on the street across from the police station or across from any house in Brookline and goes to do something, haven't they used public property to enforce civil enforcement, whatever civil detainers? And if they go into the station, which I think they have, and talk to the front desk, is so-and-so here and being released, we don't cooperate with ICE, but I think they answer the question and say, yes, so-and-so is here. And they go outside and get detained. Haven't they used town property to enforce civil enforcement? Now, I wish they would not be able to, but I don't think this language is clear. And I think it's going to get all the executive orders scrutinized, and I worry about them being tossed out. I'd rather see the proclamation stay in place and have general orders be studied more carefully to address the kind of issues I'm talking about. A couple of other things have come up, and I'm going to address them very briefly. I sent you a 2-page analysis based on my speech last week to the select board, and I sent you the Vera 7-pager. And one other thing came up recently, like, for instance, Susan Harris said staging is narrow and it's like the state provision, but the language talks about more than staging. And the state provision, I think, has the same flaw in general. The question of civil enforcement, I've looked at that just in the last few days because of the amended article that I saw, I think Sunday, but that's just yesterday. Anyway, the point is that I don't think this, I hate to use the word, trumps the provision that a violation of the bylaws, any violation of a bylaw, is a misdemeanor. And the non-criminal disposition option, I'm very familiar with it. It doesn't undo the fact that this is a misdemeanor, which will get strict scrutiny out of the Attorney General's office for void for vagueness. I don't know what the cops are supposed to do if they see what the example I just said to you, what, say to an ICE officer, look, you're not supposed to be here. I'm going to give you a ticket to go to court for a civil infraction. It puts the police in a ridiculous position, and it makes this whole thing, I view, needing work. So I think it should be a general order, keep the proclamation in place, and study this better.
Okay, thank you, Marty. We appreciate that comment. Who's next? David Mark.
Jocelyn Murphy.
Thank you, David Mark, and thank you to the petitioners for putting, obviously an extraordinary amount of work into something that's a very important issue. I have a comment about scope. It's a comment because the question is really in the bailiwick of the moderator. But unless I'm mistaken, this bylaw as it's amended would establish a new standard, a new bylaw standard regarding police intervention. And that strikes me as exceeding the scope of the original article, but that's not a question that anyone here can answer. I've raised it with the moderator, and I really just wanted to let the petitioners know that I see that as exceeding the scope, but I'm not the determinator. So, and then I have some questions that are basically legal. So I raised them with Susan and also with the petitioners. The first one is in paragraph 1, as amended, it seeks to prohibit the use of any town facilities for a variety of uses including specifically deploying vehicles. This came up in connection with the firearms bylaw, but a question was raised about whether a public way is a town facility, and I think it is, or it can be considered a public way can be considered a town facility. So I think there's a preemption issue there because, deploying vehicles, that would suggest that federal officials can't travel through Brookline, and I think there may be an issue there. Perhaps Susan could answer that question. The second,
the one thing I could suggest is that this bylaw could define the term facilities different from other bylaws. If it could specify exactly
Susan,
that it didn't
that's
include.
right. I mean, it could. It doesn't presently, but I think
Right, but
that's,
it could.
that would be a fix, certainly.
Should they decide to amend it?
Right. My question is whether there's a preemption issue, right? Whether federal officials should be prohibited from traveling on public ways in Brookline. That's really my question. The third one
I don't think
is,
they intend that, but you should ask them about that question.
and I am making an effort to do that. Thanks, Susan. The third question I have is regarding, I think it's in the last paragraph, which again, in my view, establishes a new bylaw standard regarding police activities. It says that a prohibited use shall include disrupting the lawful exercise of constitutional rights, and that shall be considered. And then later it says the violation shall be considered civil in nature only. And I wonder if the petitioners intended that perception. And a question for Susan is whether stating that a violation of, as described in this potential bylaw, interferes with any state or federal law relative to civil rights. Those are my questions.
Okay. Do the petitioners want to respond to any of them?
Well, some of them are legal questions.
Right.
I don't know.
I think town council Susan Harris is here. Could respond to your last question.
Sure,
I don't know the
apologize.
answer.
I couldn't exactly follow the last question, if you don't mind asking that piece again.
Okay, let's start with the easy one. The easy one is whether a public way is considered under the existing language. I realize there's a fix, but whether a public way could be considered a town facility, and if so, whether prohibiting the deployment of vehicles, in other words, the traveling of federal civil enforcement officers on public ways in Brookline can be prohibited, which is what the bylaw suggests. That's my first question.
Okay. I didn't read it as including public ways. I can certainly research that issue more. I didn't read it as including public ways. That's not listed as one of the items. I would agree that that's something we can't do, is we can't prohibit federal vehicles from traveling through Brookline.
Question came up in the context of the firearms bylaw. I think there was an effort to prohibit firearms under some circumstances in or on public facilities, and we took the petitioners took out the public way language for that reason. So I think it's similar here. But anyway, an issue to look at. The second one was, which I may not have asked. Massachusetts trespassing law requires notice to individuals before they can be considered to be trespassing. So how will notice be provided to federal civil immigration officials? That's kind of an easy question too. Maybe the petitioners have an idea.
Well, it would be that violation of this particular bylaw wouldn't necessarily constitute violation of the state law on trespassing. Those are two different prohibitions.
Prohibiting individuals from town property. Isn't that true?
Right. I mean, they would be in
town property. Isn't that trespassing? If they've been prohibited.
So this is a prohibition against staging, processing locations, going into non-public spaces, that would be a civil violation. Trespassing is a different violation under state law. The activity might be the same, but you're talking about two different legal prohibitions.
Sorry,
Okay,
if I can
okay.
just add,
Yep.
it's not prohibiting the presence, right? It's prohibiting the activity. That's why it wouldn't fall under trespassing.
But that includes driving over, I think it includes driving over public ways in
Right.
Brookline.
Oh,
Wait, Susan, please, let me finish my
Oh.
questions.
right.
And then, because I know you'll have more to say, so if you don't mind, I just want to get through my questions because so I have a question about that. That's essentially where I am with that. The third question, Susan, which I think I may have articulated badly, is that one of the prohibited uses in paragraph 1 is disrupting the lawful exercise of individuals' constitutional rights. And then later the proposed bylaw says violations of this shall be considered civil in nature only. Is that intended by the petitioners? Number one, that perception or that reading of the bylaw. And two, by saying that, does it create any interference with state or federal civil rights law?
Ichi, do you want me to address this?
Oh, sure, if you want to.
Unless you were about to. I mean, we haven't discussed this among petitioners, but my response to that would be that a violation of the bylaw is not the underlying activity, right? But the conducting of that activity on in-town facilities. And so that's the aspect that would be civil violation, whereas the underlying activity may be a different civil violation and may be a criminal violation, so on and so forth, but that would not be addressed or covered by this bylaw.
So I would suggest that might need a little bit of clarification because I think there are a lot of different readings, obviously, I'm just one person, but I think it can be read differently. And so I would suggest some clarification might be in order. Thank you.
I mean, I would also say it's the same answer as I gave before. The activity might be the same, but it could violate this bylaw and it could violate a state law. And we obviously can't affect how that violation of the state law is treated. It's just violation of this particular bylaw that's civil only.
Can I add that the proclamation of the select board in paragraph 5 said that nothing herein shall be construed as limiting the rights of any person or entity under state or federal law.
But Susan, that's the proclamation. It's not a bylaw. That's why this is different.
No, I'm just saying that maybe we need some kind of language like that in this. But the other suggestion I have is that in section 6.1, perhaps we should have, for purposes of this bylaw, facilities does not include streets, sidewalks, or other public byways, just to make it clear that what Jocelyn is concerned about is not covered.
I definitely think there's, people may disagree, but I think, some of this isn't particularly clear, and certainly there is a fix, right, with amended language. Thank you.
Okay, before I go to the next person, we have two people who want to jump into this point. But the whole key phrase to me in section 1 is without a valid judicial warrant. So that should, in my opinion, include streets and sidewalks, because then otherwise, why do any of this? So we have two people. We have Paul Campbell from the police department who wants to join in, and then Elisa Jonas has a 2-finger, which to the people who don't know what that means, it's an advisory committee term allowing people to comment on one specific point. So if Mr. Campbell would like to jump in.
I just had a very quick
Okay, Lisa.
comment, which was just related to what Jocelyn was saying, which is the same issue that's true for deploying vehicles is also true for personnel. I mean, can you limit all these people from being, let's see, for enforcement, assembling, or, what does it mean if there's two officers there from ICE and they're assembling? Is that legal? Is that not legal? So I'm just adding on to Jocelyn's concern about deployment of vehicles. And I also wanted to add what Marty already added, that clearly it says town facilities. It's all town facilities, even if the others are even if some of them are listed. That's it. That was my two finger.
Okay. Paul Campbell, do you want to get in on this now or hold off or?
Yeah, I can just jump in quick.
Sure.
So we were talking about paragraph 2 and the second sentence, and my concern is, does it do the opposite of what I think is intended? I think what I'm hearing from town council is basically, if the public is allowed to do something, we can't prohibit the feds from doing the same thing. So in the police department, pretty much every day, we allow members of the public to come into the police station lobby and sit and wait for prisoners to be released. Well, that hasn't really been an issue with ICE. They've waited outside. This bylaw would seem to codify their right to sit in the lobby right when the prisoner is getting out and take them into custody on police property in the police department lobby, because we allow that to members of the public every day. We don't identify who people are. People come in, they're waiting for a prisoner. They say, I'm waiting for this prisoner. They take a seat and they wait for them to come out. That was one thought I had. I did also wonder if the statement that says access to public buildings provides specific services to members of the public and conduct town operations, and to be used for only that purpose. I did wonder if that might have some unintended implications. The homeless person who walks into town hall or the library has no real interest in town services, but just wants to be inside. And I'm sure there might be other incidental things that I haven't thought of. I'm just not sure if there would be more implications. We're thinking about this in the narrow context of immigration enforcement, but we're making it a bylaw that is going to apply generally. And I just wonder if there are other implications there. And that was all. Thank you.
Okay, thank you.
Perry Grossman is next.
Yeah, thanks a lot. First of all, thanks a lot to the petitioners for your work on this. It's a really important issue, and there's been a lot of great questions raised. I'm sorry it's getting so tricky, but clearly a lot of issues. And my question is related. I wanted to understand what staging is. Could ICE officers park in the town parking lot and say, we're just parking, we're not staging, and then later drive out onto the street and apprehend someone from the street or from the sidewalk? So that's another similar scenario. Thanks.
Okay, thank you, Paul. Perry, Neil, you're next.
Yeah, thank you. Two broad comments first. I'd like the petitioners to think about this one. You don't have to answer it right away. But 6 months ago, we had town meeting members afraid to stand up out loud on the record to the Trump administration. There were threats of walking out unless we had an arguably less than legal secret vote on a resolution that was brought in November town meeting. And I'm not seeing any of that reluctance in the two articles that we're discussing this evening that were brought. And it is curious to me as to what may have changed. Secondly, and this is a frustrating comment. Was probably several years ago, I brought a warrant article calling for every warrant article to have a lead petitioner. It's to me frustrating to the process when subcommittee meets, discusses, and debates, and we hear that no petitioner has the authority to, in effect, negotiate and agree with subcommittee because, as Chi said, well, we draft as a committee, so we have to circle back after. That to me just frustrates process. I much prefer to have somebody representing the petitioners authorized uh, to agree or disagree. Let me go through some of the specifics I have, and I'll try not to be too redundant again. But starting with the question of facilities, which I think should be singular in any case, the presentation talked about property, right? But the warrant article draft, the motion is facilities. And I think we don't know, based on the conversation we're having here, what facilities are specifically. Otherwise, let me work my way down. Okay, so non-public spaces of public buildings shall be off limits to the activity of civil immigration officials in the absence of a judicial warrant or court order authorizing their presence therein. So the there just hasn't been changed from when this was officials. But it begs the question of what about the rest of us? There isn't anything in the bylaw that prohibits me from doing the same thing. Yet I suppose I'm not allowed to jump the town clerk's counter to the private side of the town clerk's counter. And so what we're doing is proposing a bylaw that would apply to civil immigration enforcement, and the bylaw as a whole is silent otherwise on that. Paul, thank you for raising the access to public buildings solely for the provision of specific services. I'm not the only one who stops in town hall on my way to and from because it's a convenient place. There's Wi-Fi. I can check my email. I can just sit there. I can use the restroom. Is that now a bylaw violation, which is going to have to cause the town to document and promptly notify the town administrator, and that's a violation, civil or otherwise, is troublesome to me. The notification of the town administrator's office, I don't think we actually have a town administrator's office. We have a select board office. I'd suggest if you want notification, it be to the town administrator. Is the authorization to seek relief now out of the proposed draft? Town administrator is authorized to seek relief. Is that still in the proposed motion?
It is not in the proposed draft. The moderator did not think it was appropriate. And actually, it was never in the original. Everything in 3
okay.
would be added.
Okay, so that's all right. So that's not there. The absence of a duty to intervene approved by the select board. If there's a duty to intervene under some other law, some other regulation that's not been approved at the state level, for example, that's not been approved by the select board, I don't think you want that limitation. If there's a duty to intervene, there's a duty to intervene. So separately and sort of overarching is how does this actually work in practice? And so let's say ICE is waiting on the sidewalk outside of the police station. Someone is released, they bolt across the street, they run into town hall, and they jump the town clerk's counter. And ICE chases them and jumps the town clerk's counter. Then what? The town clerk does what? And in what form, and what's going to happen? Do they call across the street to the police station? Do they call the 6th floor to tell the town administrator? What happens here? What are we asking for? In actual practice, how does this work? So it's not rhetorical, it's a real question. How does this work?
Oh,
Does
you want
any-
me to answer?
Please.
I mean, I assume that the incident gets documented and that the town administrator, per the proclamation, actually would go to court for an injunction to stop them from doing that.
So what I'm hearing is it doesn't do anything more than the proclamation does, because the town administrator is not obligated under bylaw to do anything. And so it gets documented, written in a log that, you know, ICE,
Well, it also
ICE did
gives the
X on a particular date.
It also gives the town employee authority to say, our bylaws prohibit this.
Okay.
Stop, you shouldn't come back here. Our bylaws prohibit this. Now, whether ICE follows that or steamrollers the employee might be another topic, but at least it gives the employee the ability to say, our bylaws prohibit this. You know, the proclamation still exists. And as I said, we would have been happy to put the injunctive authority into the bylaw, but you know, the moderator made his call.
Right. So I mean, I think that under the current circumstances, whether it be bylaw or not, that the town clerk has the ability to say to me that, excuse me, you can't be on this side of the counter. Right. So they have the authority to say that because nothing prohibits them. And I don't see where we're adding any enforcement here. And I don't know, based on what I heard from the chief, that we're giving our police officers any enforceability here, other than their duty to intervene. And so, as I said before, ICE can't access private space under the bylaw, but the bylaws say nothing about anybody else. I do have concern, as Marty stated, that a review by the Attorney General opens up the risk of all of the executive orders, including the proclamation, being declared illegal. And I'll remind the petitioners, including those who were petitioners on as compared to this, a relatively benign renter's handbook, that there are cities in the Commonwealth that require landlords to deliver renters' handbooks to tenants. And specifically, the Brookline proposal for a bylaw didn't include that provision because of the perceived risk that the Attorney General would call that would invalidate it. And they didn't want to go there. I think this is way higher odds than that. I think that everything else I had was covered. Thank you.
Okay, thank you, Neil. Chichi, do you want to say anything else before we go on?
Maybe I could just briefly speak to Neil's last point there, because that was a reference to the renters handbook bylaw, which we passed at a previous town meeting and actually was just approved by the Attorney General. I think there's a couple key distinctions between that case and this. One is, in the case of the renters handbook, the programs that had been put in place in the other communities were mature programs. They'd been in place for several years. They had already become, I think, an integral part of the tenancy process in those cities. And we were given a heads up by town council that, if we proceeded with the model that had been used in elsewhere through ordinance, that there was real risk to jeopardizing mature programs that people rely on and have real impact in their lives currently. I think we're in a slightly different situation with these proclamations or executive orders in the other communities because these have largely not yet been legally tested. And I think to Neil's point, the stakes are substantially higher. We're talking about, I think, a very fundamental issue of public safety and civil rights protections for big swaths of the population. And I would suggest that if a bylaw with the near identical text of one of these proclamations is going to be struck down by the Attorney General, that might be something that we need to know sooner rather than later. Because if that is the case, then really those proclamations and executive orders that have been put out are fig leaves. So if they're not legally enforceable and the Attorney General believes that, I think that's something residents need to know. Because those proclamations, I think they're important for setting policy, but they're also important for communicating legal status and protected status in certain key public areas to vulnerable members of our communities. So if those proclamations do not carry the force of law and are unenforceable, I'd like to know that, and I think others would too. And if they are enforceable by law, as I think we believe they are and can be, as we adjust the language on this to satisfy some of the concerns that have arisen, then I think it's equally as important that we provide a legal pathway forward for other communities to codify these protections. So I think those are some key distinctions between these two cases that really matter here.
Okay, thank you, Alec. I guess I'm next. There's nobody else in the chat. Chi-Chi, you want to respond?
Oh, and I would only add that we have seen legal opinion to the effect that it is permissible to prohibit the staging and processing activities on town-owned or state-owned property.
Now, what about the non-public spaces?
So it was about state-owned. In this particular, it's a state-owned property, but I would assume it applies to town-owned property. The issue with the renter's handbook had to do with home rule authority, but municipalities have authority to dictate what happens on the property they own.
Okay. So I'll make a couple very quick comments and then a question I really want to get into. There are some loopholes in this. For example, the district courthouse across from the library, it's not town property, so that would, I guess, not be included in this. Route 9 is a state road, not a town road, so I don't know whether the town or the state owns the sidewalks on Route 9, but I'm just throwing that out there because, there could be some other areas that we haven't thought about. Regarding the part about the injunction, where we're asking the town administrator, once he gets a report, to then pursue an injunction. By that point, it's way too late. It's been done. ICE is gone. The person they've arrested is gone, probably to another state where a Massachusetts judge has no authority. So I'm not sure what the seeking the injunction would actually do realistically. It reminds me a little about Schumer, who said that we sent a very strong letter to President Trump. It's like, yeah, okay, they're going to do it anyway. I have concerns that this bylaw is going to be completely ignored by ICE, claiming federal supremacy here. And I'm not really sure that we have any teeth in this to do anything about it. One of the things that I liked, that it was strong, but in the last part here, section 0.4, it says the officers will not interfere with federal law enforcement operations in progress, even, I guess, if there's no judicial warrant. So that sort of contradicts the illegality of the first part and says, it's like, yeah, you're robbing the bank, but we're not going to interfere with that. Because even though it's illegal, we're just not going to interfere. I do have a concern that we are putting our police officers into an absolutely impossible position, where we're telling them on one hand, this is a crime and you're supposed to, do what the bylaws say and that enforce the laws of the town. But at the other hand, it says, this particular time you will not interfere. If there's a child being taken by ICE and we're telling the officers don't interfere with that, I mean, there's a serious conflict here which needs to be addressed so that the police know that they're on stable legal ground. Along those lines, let's say an officer does decide to intervene for whatever reason. Could ICE then arrest the officer and charge them with obstruction of justice? I mean, that's another consideration of our police officers, that we need to give them, immunity here if something happens and the ICE wants to arrest the officer for interfering. There has to be some language in there which indemnifies them, I think. And so I'm a little concerned that there really is no teeth in there. It sort of gets watered down in section 4. The one thing I do want to see if I can get an answer to is that Tommy Vitolo mentioned that there is some state legislation to do basically this. And I'm wondering if, on a town level, going up against the federal government, we might not have any way to do much. But if the state legislation goes through, that would also take Brookline into the same position as the rest of the state. And would it make more sense to wait on this, on 17, until we see what the state is going to pass, and then, see if that's enough and that does a job and puts us in a better position to enforce something like this? Or do we really need this anyway, even if the state passes legislation? That's my question.
So I would say, with respect to your last point, I would need to see the legislation. But if it's like the governor's executive order, the executive order only dealt with state-owned property, and the state doesn't own like our schools and our libraries. So we would still need a local ordinance. With your concern about the fourth paragraph, 6.4, we put that in to address the concerns of the police department, because they said they did not want to get in the middle of ICE doing something. We would be more than happy to take it out. And we're doing this to accommodate, different interests. But, we'd be happy to take it out.
I'm just not sure it's enough, because there's still the conflict there. I wish this was tougher. I wish it had more teeth. And this is personal for me. So I really would like to see something passed. I would really like to see this, do it in a way that protects the people of this town without, the legal issues that may come up. So I'm not sure this is really ready, but I like where it's going. Certainly these amendments that we have on the screen here are better than the original article, and it addressed some of the concerns that I had. So that's all I have. I do want to note that the chief put something in the chat. I don't know if you want to comment, Chief, on that, and so did Marty Rosenthal, so we can call on both of you if you want to jump in. There's nobody else in the queue.
Yeah, I think it's just important to add clarifying language that, at least my understanding is, when we're talking about duty to intervene, when we reference it in the policies, it's specific to that Mass General Law, Chapter 60, Section 15, where it's, when it's an obvious and excessive use of force and the officers have a reasonable opportunity to intervene. So it's not just a duty to intervene, plain speak, like we see them, carrying out an arrest that would violate our policy. It's specific to issues around excessive force and having a duty to intervene when we observe those violations and have a reasonable opportunity as defined in that law to do so, to intervene.
Do you have any concern that officers might be brought up on federal charges if they're seen as obstructing a federal, ICE raid or anything like that?
Very much so.
Okay, before I call on Marty, Neil Gordon had a two
Yeah,
finger.
my quick two fingers, if you'd like to see what's going on at the legislature, the House has passed a bill. It's on its way to the Senate.
Okay, thank you. Marty?
Well, I'm trying to see, I put a few comments in the chat. I didn't know I'd get called on again, but just starting with the last one, the duty to intervene, I was just trying to check it. And look, I certainly welcome having a duty to intervene. And I know that it's incredibly fraught with risk to local police to try to intervene when ICE is doing what they do. So I'm not saying this lightly, but I think it's an important element. I don't think it should be in the bylaw because of the reason Jocelyn said, but I also think it's confused in both the proclamation and in the resolution 25, because the current general order 50 does not cover non-Brookline officers. I think that could be amended. I think it's the demonstration article that includes non-Brookline officers if they impede a demonstration. But all right, so the other question that I had was the trespass statute. Whether you use the word trespass or not, this is basic. I don't see any difference between this and a trespass law, and I think it'll get viewed that way by the Attorney General for strict scrutiny. And the word facility is almost irrelevant to that particular provision. Everyone's focusing on the word facility, but then it says including parking lots and public parks. Why doesn't it include streets and sidewalks? Or the lobby of the police station? That's certainly a building. I guess facility usually means a building. I think there's a state law for municipal property, but it's very, very limited. It includes mostly some state properties like state hospitals. And this is part of my reason that why I'm afraid of everything getting thrown out and Brookline being to blame. I still think the proclamation should stay in place. The general order should be revised, and don't take the risk of getting the executive orders thrown out everywhere.
Okay, thank you, Marty. Susan, can I take this down? Or do you want to keep it up?
Yeah, no, I don't have anything to add for that. So yes, if
Thank
no
you.
one else does, that's great.
All right, so there's nobody else in the chat. I don't know if anybody else wants to chime in, but now would be a good time.
Okay, so the next step would be to consider whether we want to suggest any additional amendments at this point, or whether we're not prepared to vote on this. There seems to be a lot of questions about that we don't have answers to yet.
My suggestion is that maybe the petitioners could ask the Attorney General's office the questions that we've been raising here regarding the language and whether it might cause the other things to be ruled illegal, and then maybe make amendments, and we can come back and vote on updated language at that time. But that's just my opinion. We can whatever.
What other perspectives do other
we're told
members feel?
So we're told that the select board is going to be recommending other changes in language that we haven't seen.
Right.
We've talked about
Tuesday.
We've I don't know. We've talked about the need for some of the terms and provisions in the current motion to be better described in terms of defining terms. That's not something we can do on the fly. I think we need to, somebody needs to identify those terms that need definition and, come up with some draft language. And so I would prefer to wait until we know what it is to vote on something we know is imperfect and is going to change. We're only going to have to reconsider anyway.
And they would also give the petitioners a chance to look at the State House bill. I'm going to call
David Mark, if you can't see it, there's a hand up.
Yeah, I was about to call her, Yolanda Rodriguez.
My name is Yolanda Rodriguez. I live in Precinct 8, and I have no connection to anything. I'm not a part of any of this, but I just wanted to thank you for bringing this article up, especially after listening Monday morning to the discussion on birthright citizenship. I don't know that there are too many of us here in this town or anywhere really who can feel as though nothing at all can happen to them because they're 100% citizens. So I just wanted to say thank you. I know this is a tough road. I don't know how it's going to end up. And bless you, I could never be doing what you're all doing right now. But thank you for doing it, and I appreciate it.
Hey, Liz Linder.
Yes, I really appreciate the spirit of this article. And at the same time, it seems fairly complicated in terms of unintended consequences that we might experience. So what I'm wondering is, I would love to hear an example of something that this article in particular in Brookline would thwart based on the fact that there are already some regulations in place. Like, I'd love to hear an example of how, you know, what this could potentially thwart that wouldn't already be thwarted based on what we've got in place. Thank you.
Chi-Chi?
So, I mean, first of all, I think it's important to step back a bit and think about the fact that just passing this would send a message to the immigrant residents in Brookline that we do not permit this sort of heavy-handed activity by ICE in our town buildings. And we don't permit them to do staging or assemble operations. Now, push comes to shove, would we win? I don't know, but we're taking a stand. So first of all, this is about taking a stand. It's about giving some sort of backup to town employees who might say, the librarian who might say, you can't go in there and go arrest that person. That's the library staff offices, and I don't want you going in there to pursue an arrest. Or, you know, jumping behind the town clerk's counter or such. Is that already something they shouldn't be able to do? Yes, but having a bylaw that specifically says civil immigration activity is not permitted gives them additional backup to say, you can't do this. Is the ICE officer might do that anyway and barrel in? Maybe. I mean, I work in an area of law where we see oftentimes not only private litigants, but like the attorney general or the federal government has to come in after the fact and get an injunction or say, don't do it again. That happens a lot. It's the best we can do. Sometimes we can't stop it right away. Would it be better if the police could intervene? I think so, but they've expressed a desire not to get involved. And petitioners have tried to accommodate that in the warrant article. We've been trying to be very accommodating, but at the end of the day, we do intend to bring a warrant article. So the question is whether the warrant article includes all of the terms and provisions that we can agree on, or we just bring it.
Mm-hmm.
Okay, Donnell.
Thank you, David Mark. So I just want to thank the petitioners for putting this on the table. I can see you've done a lot of work already. There's been a lot of lines in it and amendments already done with it. I think one of my fears is it's going to be like another silent vote on this. Like, I wasn't sure if Neil's question was answered on what changed in the town. Apologies if I missed the response to Neil's question. So that and I'm envisioning elected officials getting arrested like we've seen on the news before, and like the police getting jumped by the ICE agents for if they see an aggressive arrest or something from ICE, they intervene, and then that's a scuffle with the police. Or so I don't know. I have some reservations. I mean, I appreciate the article, like everyone said. If it came down to it, I wouldn't vote for a silent vote. I didn't do that last time. I'd like to see who votes what on this. And I'd like to hear from the AG. Like, if y'all, I know that's a big ask from us. But if y'all can like reach out to them and see what, get their thoughts, I'd appreciate it. But at this time, I'm gonna vote no on this. I just want to throw that out there until we hear back from the AG and everybody. Thank you.
Thank you, Donnell. Alec, you unmuted yourself.
Yeah, I was just going to say that, I think we're happy to reach out to the AG's office and certainly, get them to see if they'll weigh in. I will just caution members of this committee that we've had similar questions arise on other bylaw proposals in the past, and I have on multiple occasions reached out to the Attorney General's Municipal Law Review Unit, and they are, to put it mildly, extremely loath to offer prospective opinions. So we're happy to do that outreach, but I would just, caution that we may not get that much back from them. In the meantime, as has been mentioned, we are continuing to talk with the select board. We'll be back there tomorrow night. And I understand we'll be discussing some more amendments there. So, I think it sounds like it's likely unavoidable that there will be another version of this in front of you at some point. Obviously not as a member of the subcommittee, but as a petitioner, I might encourage a little patience here as we've, discussed this evening. This is really, really complex. And we really are trying to be responsive to the concerns that have been raised and balance the competing questions here. So we're going to continue to work hard on this. And, I think we're getting close. And the next, version that you should see, I think will address a number of these concerns.
Good. Thank you. That was helpful.
Okay. One thing I wanted to ask, based on the petitioner's comments for the select board, it was my impression that the primary goal was to position the town better so that we could get injunctive relief. Should there be a series of incidents in the town? Is that correct?
I think part of the rationale was, should the town want to seek injunctive relief, a bylaw would be more enforceable or a better hook for injunctive relief than a proclamation.
Right. So that my sense was that you didn't expect the police necessarily to be intervening or town employees to risk their lives to intervene, but rather that we're trying to lay the legal groundwork to enable the town to go to court and get an injunction. But it might not, in effect, change the initial situation should ICE be doing things that similar to what they had done in other cities, and appearing en masse and in, with masks and all of that. We're not necessarily asking our employees to intervene, correct? That we're simply establishing the record that we then can go to the courts to get the injunction ultimately. Am I misreading what your purpose is, or?
So one of the things we wanted to do was to hew closely to the proclamation, because that had been passed by the select board, so that there was already a solid basis for it. And yeah, that proclamation talks about seeking injunctive relief and that the police should not interfere without a duty to intervene per the general order. So yes, it was meant to basically just codify the relevant parts of the proclamation.
Mm-hmm. And one concern I have is that I don't want to risk any staff lives. So that we were talking about if ICE suddenly wants to go behind a counter, we're not talking about in the police officers intervening, but just a clerk in some department of the town. We're not expecting that they're going to necessarily make a stand. They could say, well, this is illegal, but we're not going to be instructing our personnel to resist, are we? Or are we going to perhaps send a conflicting message to employees about what their obligations are, and inadvertently become, create situations where their well-being may be at risk.
Well, certainly we would not want any town employee to be harmed, for sure. And we would not want them to have to put themselves, their safety on the line. However, if they did want to tell ICE, you're not permitted in the library staff offices, or you're not permitted inside the public health building, then we want to give them the authority to say that.
Mm-hmm. Even though they might then be arrested for obstruction of justice, and then only days later, they might then find out, oh yes, we actually do have a legal argument, but they will have gone through a lot of potentially dangerous situations.
Again, there's no expectation that, and certainly there's no expectation in the bylaw that they do that.
Mm-hmm.
Yeah, I think the expectation laid out in the bylaw is that they document. And that's
Right.
something that can be done without,
Right.
a direct confrontation with federal agents.
Right.
Yeah, no.
But I guess
wait, I'm confused now, because is there no expectation that if someone is violating a bylaw, that someone in a position of knowledge or authority, a town employee, doesn't tell that person, excuse me, but you're not allowed to do this? Is the expectation is that everybody will just be silent about it?
Well, I
I
guess
find that as an unreasonable
I would ask,
expectation.
is the expectation that they do so under the auspices of the select board's proclamation? Because if so, then I think a bylaw actually provides firmer legal ground and better clarity for them to stand on, if that's the expectation.
Yeah, but that's not the point I was making. The point was that, they're not expected to say anything, perhaps, and put themselves at risk. What's the expectation if someone is violating the bylaw?
I think what the text of the article that we're looking at this evening makes clear is that the expectation is that there be documentation. They record and document the incident. There's nothing in that language that requires a town employee directly confront a civil immigration officer, just as I don't believe there's any language in the proclamation that makes that requirement clear. So that the baseline compliance with the article, as looking at the text we're considering tonight, is document, not confront.
And so does that apply if I jump over the town clerk's counter too, that no one would say anything? I'm trying to understand what the standard is and what the expectation of the employees are in a way that they understand it.
I would imagine the select board would have a policy guide on that. If you go to the library and the librarian sees somebody ripping pages out of a book, they can say you're not supposed to do that, and then they call the police, but they're not really needed to go and intervene and try to snatch the book away.
What they don't do is they don't send an email to the town administrator.
Well, there'll be a policy where the select board says, this is what we expect for you with this warrant article. You can say this, or you can not say
The bylaw doesn't ask the select board to establish policy.
But realistically, they're going to do something. They're not going to just leave it unanswered.
Under what authority are they augmenting regulations relating to this bylaw?
They set policies all the time for the stuff like this.
Well, they don't just haphazardly have policy. They have policy within their authority.
And we have Liz Linder next on the list. Susan, do you want to?
Yeah, I guess I haven't put my name on a list, but please add me to whatever list. Yeah.
That's an old, for some reason that just reappeared.
And I would just respond to the original question that there are many provisions in the bylaw that require enforcement, but we don't get into the details of what the staff are actually supposed to do or how they're supposed to enforce that. We leave that to the town administrator, to department heads, to implement in their own, we don't want to micromanage the staff.
Exactly. All right, so
can I?
Yes, you're absolutely.
Yeah. So I think ICE is not a law-abiding citizen in any respect. And so we have to, Neil's question is really apples and oranges. We are not treating ICE the way we would expect to treat a typical Brookline resident who is violating a bylaw, and assume that if we give them a ticket or some sort of notice of an offense, that they're not going to use violence in return or have grounds for accusing someone of obstruction of justice. So I think that this is a unique situation. And I don't think that we want to necessarily encourage employees to take action that will seriously put their lives in jeopardy in any sense of the word. And I don't think we can have any certainty how ICE will react to any kind of comment. Oh, well, this is against the law in Brookline, so you shouldn't do this, because they could easily arrest any employee as someone who's obstructing justice and argue about it in court 2 weeks later. But that person, the employee, will have suffered the consequences. So I think we have to be careful what our expectations are. And I don't think we want to, even though we want immigrants in Brookline to know that we care about their situation and want to try to help, I don't think we should give them false expectations that if something is happening in town hall about something, that people will automatically intervene on their behalf, because that may be unrealistic. And it's a very difficult situation. And to the extent that this bylaw creates misimpressions of what the town is prepared to do, I think that might be detrimental. And I hadn't really considered that before. But it's clear that Neil has very different expectations as to what having this bylaw on the books means than what some of the people who are offering this and are in favor of this have in mind. And I am concerned that it may have unintended consequences that no one really wants in terms of the safety of the town's employees. So it's just a factor that I think should be considered in drafting the next version of this article.
I'll just say
So-
briefly, the last thing I'm going to say about this is that I would like to see this passed in some form. I would like to see it stronger than what it is now. I'd like to see the problems with the language and the ambiguity tightened up. The one thing I can't get past at this time is the enforcement issues that the police are concerned about. We have to deal with that. But I would certainly like to be able to be in a position where I can vote for this. So I'm hoping that time we meet, that'll happen. And Chief Pastor has her hand up.
I do, thanks. I just wanted to sort of bring it back to the reality, and I appreciate comments that everybody has made. You know, regardless of whether it's written into this particular bylaw that it's a civil infraction, just how things play out in real life is that we're the default agency. When no one knows who to call, they call us. They don't, and that's true for all bylaws. And sometimes we arrive and we get there and we say, you know, this belongs with the building department, this belongs with the health department, and it's an advisory capacity. Forgive me, I forget who said it. We're not dealing with, you know, your average Brookline resident when we're responding to a call like this. We will be called, and then you have one law enforcement agency fighting with another law enforcement agency, potentially looking at my officers being, you know, faced with obstruction of justice charges. And that's the best case scenario, is that we're faced with charges. That, you know, worst case scenario, it obviously becomes a violent confrontation. So I just want to kind of bring it back to what we actually see on the ground every day, which is that you know, our department, for better or worse, is just kind of the dustpan for all things, for all problems in town, and we show up and we deal with the cards that are in front of us. But this would be a particularly dangerous situation.
Right, thank you, Chief. I don't have anybody else in the chat. We might.
Okay,
ready to move
so
on.
my sense then is that we are not going to take any votes on amendments of this. We're going to continue our discussion to a later public meeting on this. And we can discuss a date at some point, but one possibility is next Monday evening, because I think whatever time we choose, we're going to need enough time to amply discuss this. I can see from this discussion that just assuming we can settle everything in an hour is probably unrealistic.
But Susan, 1 week from now is not enough time for the petitioners to finalize their language or read the state bill that's in the State House or
Okay.
do any of
Because I
that.
know
We
that the
need several weeks before.
select board going to be considering this again tomorrow night. Do you think that they're not going to take a vote tomorrow night? Is that your sense?
I would doubt that. They tend to wait until the last minute for something.
Okay.
I would
Okay.
suggest that we ask the petitioners to get in touch with us with some dates of when they think they have their final version ready.
Okay.
Then we can schedule from there.
The full AC is not going to be considering these two warrant articles until April 30th, just to put that into perspective, because I thought that we might need some additional time for future meetings. So, so that does give us some time, but we need to figure out what people's schedules are like so that we can be certain that we have a quorum for whatever meeting. So yes, let us know what dates when you think you will have a more final version.
Happy to do that asynchronously, Susan.
Okay, so let's move on now to warrant article 25. And Chi-Chi, are you the one doing the presentation on that as well?
No, I'm not. Alec and Jessica are. My apologies, but I have to leave at 7:30. I did not think this was going to take more than 2 hours. But Alec and Jessica are there, are here, and I will try to listen in as well, and hope they can answer questions. Thank you.
Okay.
All right. So I can share the slides now, Susan, if that's
right. Oh, and Chi-Chi, if you could send your visuals to us so that we can then post those and include them with whatever report to the AC takes place.
You mean the PowerPoint? Yeah, I can send you the PowerPoint.
Yep.
Chi-Chi, nothing in advisory takes less than 2 hours. Sorry about that.
You know, usually it's like 2 hours per warrant article.
Well, that puts us on pace.
Actually, yep.
Yep. Wood and bark we do in less than 2 hours.
All right. Well, good evening, everyone. Alec Lebovitz, town meeting member, precinct 8, also member of the advisory committee. Here this evening as one of the petitioners of Article 25, which we really view as a companion article to the one we just considered, in that where in Article 17, we kind of set out to do what we could via local bylaw. Article 25 seeks to call for a suite of other local and state level actions that we believe benefit Brookline in suspending cooperation with ICE, which, as we've discussed at length tonight, is really a lawless and dangerous agency currently. So I'll briefly talk about some of the state-facing provisions of this resolution, then I'll turn it over to my co-petitioner, Jessica Kiko, who's going to talk about some of the more local-focused ones. On the state level, there's really 3 main asks that are included in this resolution. One is we simply condemn and call on our representatives to condemn the actions of the Trump administration and particularly federal officials in civil immigration, specifically for the actions that they've taken that are well documented in targeting people for immigration enforcement actions on the basis of their race or perceived race, ethnicity, their spoken language, or their political preferences. We really feel this is just completely anathema to everything that the United States and Brookline stands for, and it's just something that can't be tolerated. We also call on the Healy administration to take one action, which is we request that they exit from the remaining 287G agreement that the state holds with ICE. That is the official legal mechanism through which cooperation agreements are negotiated between state law enforcement agencies and the federal government. In our case, the 287G agreement that is still active is held by the Department of Corrections. This is the only remaining active such agreement in New England, and we feel given ICE's clearly demonstrable inability to safely and humanely hold people that are referred to them for civil immigration actions means that the state cannot in good conscience continue to turn prisoners over to ICE. And finally, we call on the state legislature to take action similar to General Order 43 as issued by the Select Board, particularly prohibiting any cooperation between state law enforcement agencies and ideally local as well under the auspices of state law with ICE. And with that, I'm happy to pass it over to Jessica to talk about some of the local facing provisions.
Thank you. So hello, everyone. Jessica Kiko. I'm a long-time resident of Brookline. I have kids both at BHS and at Runkle. And I'm also chair of the Immigrant Advancement Committee, which is a committee of the Commission for Diversity, Equity, Inclusion, and Community Relations, where I've served since 2018. My day job is as an immigration lawyer and director of training at the Massachusetts Immigrant Refugee Advocacy Coalition, MIRA, though I'm here in my personal capacity. I think in the interest of time, I'll jump right into the 3 local planks that I think are likely to generate most discussion tonight. The first being withdrawal from the Boston Regional, it should be Intelligence Center, not Information Center. When we spoke with the police department just a couple of weeks ago, Chief Pastor and others highlighted the value of the shared resources that Brookline has access to through the BRIC. But the BRIC is not just about pooling resources. It's been well documented over years that the BRIC includes significant surveillance efforts, including surveillance of lawful political activity protected by the First Amendment. We know that the BRIC, which was created as an anti-terrorism tool, has drifted from that mission and has collected information on everyday people who are not suspected of any crime. BRIC has monitored social media of Black Lives Matter and Occupy Boston activists, as well as Muslims. We know that the BRIC disproportionately collects information on Black, Latino, and Muslim communities, so much so that 98% of the people that are monitored in their gang database are people of color. To the extent that BRIC exists to facilitate information sharing among law enforcement agencies, we're confident that needed information sharing and collaborative relationships exist with our neighboring towns and sister agencies well beyond the handful of towns that are part of the BRIC. And most importantly, despite assurances to the contrary, information shared through the BRIC can and has been accessed by the Department of Homeland Security, an agency that I think, especially after the conversation we've just had, we can all agree is marked by lawless, unconstitutional, and often violent behavior. And we know that this information has directly led to deportations. And this is true even after the Trust Act was passed in Boston. Town policies and our values are that we're not going to use town resources to facilitate civil immigration enforcement, and being part of the BRIC does just that. The second plank of the resolution that I wanted to speak to is the limiting of fingerprint sharing with the Department of Homeland Security. We know that when somebody is arrested by our local police department, regardless of whether charges are ultimately brought or whether the person is found guilty of anything, they're fingerprinted and those prints are shared automatically with our federal government. And under the program called Secure Communities, they're shared with the Department of Homeland Security. So we have policies that are meant to ensure Brookline doesn't insist in civil immigration enforcement, but the sharing of prints does just that. And because we can't control what happens to the prints once they're shared with our federal agency, limiting the sharing of prints for children and for those with lower level offenses would ensure, again, that we're living our values, but would also have the helpful impact of making sure that people are around to see their criminal proceedings through, right? That they're not whisked away by ICE with a pending criminal charge. And also would address disparate consequences of someone being arrested and having to go through the criminal process and receiving whatever sentencing comes of that, versus someone being arrested and then being separated permanently from family, facing long-term immigration detention and deportation. And the last topic I wanted to address this evening is the WASI funding. Among other things, it's our understanding that this funding supports our participation in the BRIC, and that the purpose of the WASI grant and the collaborative is to fund and make that diffusion center of the BRIC function. I think many of you already know that the federal fiscal year 2025 Notice of Funding Opportunity, the NOFO, required grant recipients to spend 30% of their fund among national priority areas, including a mandated spend of 10% on what they called supporting border crisis response and enforcement. And the NOFO sets forth activities that would satisfy that requirement, including all sorts of things that we know already as a town we cannot do and will not do, like participating in 287G agreement, cooperating with ICE detainer, supporting other immigration enforcement. We know that there's a federal, that there's been litigation filed and that a federal court has issued an injunction on this particular provision, but it's also my understanding that the administration has already appealed that decision or submitted an intent to appeal. And all too often, we see federal courts press pause on a harmful policy from this administration, only to be overturned on appeal. Our select board's proclamation in February stated, and I quote, "The town of Brookline does not aid, abet, or participate in any way in civil immigration enforcement." So it's clear that if we take our commitment to immigrants and other targeted communities seriously, we can't apply for and continue to receive funding that has these types of strings attached. So I will end there.
Thank you, Jessica. Okay, I'd like to go around and get comments by the police chief, the fire chief, and town council.
Okay, sure, I can start. And for some reason, out of the blue, my internet connection started acting up, so I turned off my video to preserve. Just somebody please flag if I start going in and out. I think most of my concerns were addressed in the memo that I submitted. You know, as we went along, the first slide that Alec presented, no issues with any of that. And I, in fact, appreciate 43.0, you know, being called out as good policy. We work pretty hard, and I think that reflects the values, the shared values of our community and our police department. Where it gets problematic is when we get into the second slide. The BRIC really is a critical resource for our department. You know, in terms of information sharing, the primary use for our department is that's just it. We share criminal intelligence. It's not, you know, not surveillance activity, not anything that would be a violation of, you know, civil rights acts or anything else. You know, it's criminal activity. It's governed by 28 CFR Part 23. That's a requirement in order to participate in any fusion center, and that's what the BRIC is for us. It's criminal activity. We know that people who are committing crime here in Brookline, you know, they don't see borders. They're, you know, we're surrounded by Boston, obviously. We value our partners with the other UASI agencies. We share wanted flyers, we share missing person flyers, we share crime trends and patterns, MOs, and it's all with a criminal predicate attached to that. Also problematic is the provision in there, the suggestion that we should not fingerprint juveniles or those who commit misdemeanors. Fingerprinting for us is the way to identify somebody who's in our custody. We are responsible, and I am responsible as chief, for knowing who we have in our custody in order to keep that person safe. And that safety looks like a lot of things. Fingerprinting is the most reliable way to do that. There's no way for us to, you know, fingerprint somebody right now. This is what I'm waiting on confirmation from the state police. But we roll electronic fingerprints. They go into a statewide database managed by EOPS, and that those fingerprints get sent to the FBI. That is how we make identifications. On a rare occasion that somebody commits a crime and they've never been printed before, their fingerprints stay in that database. And as they go on, if those fingerprints hit on a crime committed in another community, they come back to whatever information we took in at the time that the person, faced their first arrest here in Brookline. We don't arrest a lot of juveniles. We're not arresting juveniles, for, unless really we try to look for any alternative to arresting a juvenile. But it's not always possible. And so, with that, and misdemeanor crimes would include, drug offenses, domestic assault and battery, a number of charges that I think most people would agree that we should be fingerprinting people taken into custody for such offenses. So Chief Sullivan is here. He's our JPOC for UASC grant funding. I can let him speak to the funding mechanisms. I'm happy to do so as well. And I think there was a fourth piece that had to do back with the police department. It was just about us investigating federal officials for use of excessive force. To that, I'll just say, we can certainly try. It would fall, if there's, for example, if it fell under the crime of an assault and battery or assault and battery dangerous weapon, that's a crime that we would investigate. We can't ensure that federal officials would be compelled to comply with our investigations. It wouldn't fall under an internal affairs investigation. It would be a criminal investigation, and we would do the best that we can do. That's what I can offer about the fourth point. But really, the problematic pieces are the withdrawal from the BRIC, not applying for UASC funds, especially given that the lawsuit that was recently filed, and dropping in the fingerprinting provisions.
Okay. Thank you, Chief Pastor. Chief Sullivan, would you like to weigh in on this?
I would. Thank you, Madam Chair. It's, the issue around the BRIC seems to be the major sticking point for the petitioners with regard to UASC. I don't really have an opinion necessarily about the BRIC. It's not something that the fire department or emergency management has a lot of interaction with. We do get information from the BRIC when it comes to those kinds of terrorists and shareable intelligence that would affect us as supporting agencies. But I leave it to Chief Pastor and her team to really articulate the necessity for maintaining a relationship with the BRIC and the Fusion Center. That's something that I highly depend on her expertise to be able to make a clear decision on that. The UASC grant funding, as many of you know already, stemmed out of the formation of Department of Homeland Security after 9/11, when it became readily apparent that local municipal government did not have the capacity to be on the front lines of a terrorist attack. The UASC regions were identified and continue to be identified based on their vulnerability. Our proximity to Boston makes us unwittingly vulnerable to those actions of bad actors. We've seen it recently, and we will continue to see it, especially now, given the heightened political position that we find ourselves in because of the federal government. The UASC meetings are open meetings, and anyone who was privy to that open meeting back several months ago when this NOFO came out, and that particular provision that the petitioners are identifying in there with support for the border security, I was the one JPOC who stood up and identified that this is going to be a problem. We would have passed right through it had I not stood up and said, it would be remiss of me as a representative of the town of Brookline not to point this out. And so part of my problem with the petitioner's answer to the questions today was that, there was an implication that the town staff needs to be reminded of the political atmosphere and the way that Brookline views the current administration and the actions of the ICE agents. I don't have to be reminded that. I see it every day, just as everybody else does. And I think we do a great job between, Chief Pastor and myself and the other representatives of town staff, standing up and being heard when it comes to what we understand is the political nature of this town. And so I just wanted to put that out there. We have received hundreds of thousands of dollars worth of equipment that we would never have had, and training and things that are completely benign to any of the concerns of the petitioners here that would become in jeopardy, not only for the future, but existing equipment if we were to withdraw from UASI and UASI grants. We have hundreds of thousands of dollars worth of equipment that they could just recall today because they're regional assets. We just happen to, have, custody of them right now. So I could go through a list of things that we do not have the infrastructure to support, especially in the budget situation that we find ourselves in now. So in that document that we received today, answering the questions about what the impact would be to the budget, and would it have an adverse impact? And the petitioners do not anticipate new operational spending needs as a result of this proclamation. Well, that's just not true. That we would have to. Every bit of our sheltering materials for severe weather emergencies, cold emergencies, heat emergencies, all of that would go away. And we would have no way in the budget to be able to backtrack and put all of that back together should this pass. They stated in their answers that they had reached out to town staff about the impacts of this. Well, I'm the jurisdictional point of contact for UASI. I've been doing it for the last 5 years. Not one of the petitioners reached out to me and said, "Hey, Chief, how would taking the town of Brookline out of the UASI grants affect your ability to protect the citizens of the town of Brookline?" We have CERT teams, which are the envy of every city and town in Massachusetts, and MRC, Medical Relief Corps, that their funding would be cut off. We primarily support CERT and MRC through UASI funds. Our Alert Brookline subscription, where our mass notification system comes from funding from our connection to the UASI region. I could go on and name dozens of things that don't have anything to do with intelligence sharing that are put at risk by taking this part of this resolution and moving it forward. And I can't say how difficult that this would make our jobs as public safety officials, even outside of the police department, to do our jobs moving into the future. And I caution the AC committee and the petitioners, had they asked, that this would severely affect our ability to do our jobs on many, many levels that don't have anything to do with their concerns. I'm afraid that, we're looking at, hopefully, God help us, that this is a short-term problem that we have with ICE and this current administration, that we're endangering the long-term needs and goals of this town to satisfy what is, a problem. It is a problem. We recognize it's a problem with the current administration. And so I just wanted to caution, that as we move forward.
Thank you. Just for clarification, can you say that that the safety of the town would be compromised to a significant degree if we were not participating in UASI?
I think that should something occur, that we would be in a significantly compromised position for the town's safety should we withdraw from UASI and the assets that we currently have be taken away from us, and our ability to move forward and to build on those things were we're left to our own devices. Our gas meters, our SCBA, even the SCBA that we wear on our backs at the fire department right now for everyday response, were bought by UASI funding several years ago, 14 years ago. And in theory, they could take it. They could come and say, we want that back because we bought that and now you're not participating. Would they do that? I don't know, but they certainly can. We're warned all the time as JPOCs that if you want to get rid of equipment, if it's outdated, even if you don't want it anymore, there's a process. We have to go back through UASI and say, here it is. And we don't own it. We are the stewards of it, but we don't own it. And so to that extent, Susan, yes, we would be severely compromising so many aspects of safety in town that don't have any nexus to what we're trying to do with this warrant, with this proclamation. I get it, and I support the petitioner's intent, but I think their intent is having some really significant impacts that they didn't anticipate.
Okay, thank you. Does Susan Harris, do you want to weigh in on any legal implications? You don't have to do it now, but in case there are some, because we didn't receive any memos from you concerning that.
Yes, thank you. Just where this is a resolution rather than a bylaw, it doesn't raise quite the same questions of legality. These are more policy questions for you all and for the town. If there are specific questions about legal impacts of any of the provisions, I can try to answer those as they come up.
Okay, thank you.
I go to
Okay,
speakers?
are there?
Yeah, there are some. Should I go ahead and call on people?
Yeah, I was going to say we should open it up to for public comments.
Okay,
if
so
there are any.
First up is a member of the public. Help me with the name Fatema Ahmad. Am I pronouncing that right?
Yes. Hi, this is Fatima. I'm Executive Director of Muslim Justice League. We are a local Massachusetts-based organization, and we have been local experts on BRIC and national experts on fusion centers. I know many questions have been brought up here, so I'm going to try to address as many of them as quickly as possible. One is that the issue of deportations happening because of BRIC is not, it's not just a crisis in this moment. This has already been happening, and it has happened despite the Boston Trust Act, despite sanctuary policies that has been going on for quite some time. And there are a number of immigration attorneys that we work with from CPCS, from PAIR Project, from Mass Law Reform Institute, and a number of other legal organizations that would tell you their clients continue to be deported under multiple administrations because of BRIC's information sharing, that information sharing is not based on criminal intelligence. It is often, like in the case of the gang database, based on allegations, not convictions, but allegations. And that gang database has in fact been thrown out of, federal court in a decision just a few years ago around one of these clients as something that should not be, considered. So not only is BRIC using a gang database that has had incredible concerns over many years, BRIC also includes flock license plate readers, ShotSpotter, data brokers, and a number of other databases and surveillance technologies that also have platforms that are accessed by ICE and federal law enforcement. We've seen many headlines about the ways that flock license plate readers have been shared with ICE, and BRIC runs a regional flock license plate reader system that they're setting up across multiple cities. Participating in BRIC and UASI means enabling that information sharing, even if Brookline is not, participating in the flock license plate reader system itself. Literally, the way that the UASI grants were set up was to create the problem that you're having right now, where you are dependent on them for this emergency funding, and the UASI grant will only come to the region if you continue to fund BRIC. That is intentionally so that you have these strings attached. You will have to really decide as a town, are we okay receiving a few $100,000 for this emergency management equipment and other, initiatives, knowing that the majority of the $13 million that is coming to the region is for BRIC. It's for flock license plate readers, for other surveillance equipment, for cameras that are all connected back to DHS. A reminder, BRIC is funded by DHS and set up by DHS. The entire point of a fusion center is information sharing back with federal law enforcement. That includes First Amendment protected activity. My own organization is surveilled by BRIC. Our events are regularly reported on by BRIC. There are many ICE personnel that sign up to receive those reports and other law enforcement agencies that receive those reports. BRIC did not stop the marathon bombing, but around that time, instead, they had about 1,500 pages worth of surveillance on the Occupy Boston movement. So we have seen the impacts of what BRIC is actually doing, who is actually impacted quite regularly. And that is only going to get worse under this administration. The requirements that the Trump administration has now put out is just making blatant the strings that were always attached with this funding and the kind of surveillance that was already happening. But as you all know, in this moment, that is just getting so much worse. And so honestly, it's quite exciting to see folks in Brookline take this seriously and consider pulling out of BRIC. I know that the financial implications are serious, but I hope that we can have actually a lot more conversation about this and pull in some of these attorneys who have been dealing with this directly for their clients, for people who have, been deported, and many people who get harassed regularly by the gang database and other issues that have come up from BRIC.
Thank you.
And-
Who's next?
And Jocelyn is next.
Okay, Jocelyn.
Well, thank you. And again, to the petitioners, thank you very much for raising this issue. It's certainly an issue that, should be discussed in Brookline. And Fatima, that was really interesting. So I am one of the members of the advisory committee who believes that resolutions of this nature should really be deferred to the body of town meeting. That, as an advisory committee, we're the financial advisory committee. If there's something that has a financial impact, we're the worker bees that go to work and try to figure out whether the financial impact is, what the financial impact is. So I typically do not always, but I typically abstain on advisory committee and participate and vote accordingly at town meeting. I also think we have a duty in most cases to defer to the good judgment of our department heads, unless there's a significant financial impact, and then that's, when we might take a much closer look. So I respect the opinions of Chief Pastor and Chief Sullivan, as to operations within their departments. Also, as a lawyer by trade, language is really important to me, and I think it's really important to publish language from the town that we can all stand behind. And there's a lot of language in this resolution that I would recommend edits to. And there are some things as minor as in the resolved clauses, it refers to preventing cooperation. I believe that word should be prohibiting. In other areas, there's language that refers to the unconstitutional behavior of the president and so forth. I was going to suggest putting language in that said these actions, to the extent they're unconstitutional and so forth. I mean, I just have a lot of changes, and I don't want to be responsible for 2 hours, a 2-hour hearing. So I'm happy to send those to the petitioners. My guess is this might take the same path as the earlier article. And they're just my suggestions to improve on the language. The final thing is a question that I would ask Chief Pastor, based on my century long ago experience in law enforcement. You know, I have a memory of, on occasion, and this probably happens much more regularly outside of Brookline, but on occasion, I remember that someone would be stopped and arrested for a misdemeanor traffic offense. And then lo and behold, you know, the FBI fingerprint inquiry would come up with someone who was a real bad guy. And so that's one of the unintended consequences that I worry about, notwithstanding, you know, everything that we've heard about how these, you know, how these individuals who are stopped are treated by ICE. So that's one of my questions. Is that your experience as well, Chief? Does it happen that people who are stopped for misdemeanors or traffic offenses that are misdemeanors from time to time turn out to be, you know, really serious, you know, personal injury felons that
Of course.
something we should worry about?
Of course, that's the case, and I feel a little bit guilty speaking about it, because I think Paul Campbell is on the call, but he can speak to, you know, if the group wants to hear it, his own experience when he was involved in an officer-involved shooting back in 1999 with a subject who was placed under arrest, said that he was 17 years old, gave a fake name, come to find out when we roll his prints, you know, he was actually 19 years old and had 2 homicide warrants out of Georgia. And had, you know, robbed a store up in Chestnut Hill to be involved in a, you know, shootout here with Kevin Mealy and with Paul. You know, that's one example that obviously, you know, looking at him every day is fresh in my mind, but it does, you know, people lie to us, and people have very similar names as well. So even giving us a name, for example, John Smith, without rolling fingerprints, we can't tie it to any other record. You know, very similar sounding names. One letter might be off when they were booked in a different, you know, under different circumstances. Fingerprints are really the only way to tie somebody to their state ID number.
So thank you, Chief. I would not readily let go of that tool for that and other reasons. I certainly support the, you know, the premise behind this resolution, and I will likely support it at town meeting, but it has to have the right language. So if you don't mind, I'll make a few suggestions on language changes, which I can probably do right after this meeting.
We'd certainly
Thank you.
welcome that, Jocelyn, and would love to take a look at that.
Right. That would
Thanks,
be
Alex.
great. And if you could share it also with the subcommittee, that way we'll know what you're recommending, and we'll be aware of that.
Certainly.
Right, Jocelyn, are you done?
I think I'm done. Thank you.
Okay, next up is Marty Rosenthal.
Hi, so I had a few comments on this one, which in spite of them coming from me, I would hope are friendly amendments to add things. And I'm going to go through them quickly for obvious reasons. On the submitted to the very last paragraph, I'm not sure why local legislators were left out of there, but some of my other comments are going to relate to possible state legislation. So that's number one. Number two is in talking all this over with Superintendent Campbell, he reminded me something that I've always known was parenthood and apple pie. And there's nobody that's dealt with more people under arrest in Brookline, frankly, than me, I don't think. After 20 years as a public defender and clinical instructor, et cetera, and 30 more years as a criminal defense lawyer, that the state law on a phone call within an hour, there is a state law. I forgot that. I knew it was routine. I looked at that law. It doesn't limit it to local officers. Why doesn't that apply to ICE? I know there'll be sovereignty and supremacy issues and so forth, but I think that that should be looked into. Number two was masks and name tags. I don't know if one of the legislation at the State House addresses that, but it seems to me we should ask that that be looked into, that they not be allowed to wear masks unless specific circumstances, like, whatever. And then name tags, I think that's grossly offensive. There should be an attempt to have state law requiring that. Number three was, I know something is published by Town Hall in some kind, I forget what the name of it was. I have a good friend who's a defense lawyer and well-known immigration specialist, that there's something, it may come from Mira, I'm not sure, that a card for people about their rights when they're detained or whatever by ICE. And I don't know what's on that card. I haven't seen it, but it seems to me that one thing the town should be looking at is some kind of a hotline for somebody to call that they could get advice. And I mean, and maybe it's somebody, a friend that's with them, or a relative, or someone at home when ICE comes to the door. I mean, it seems to me that that's one of the biggest problems is that ICE grabs them and there's nobody that can help or do anything, and then they don't even get a phone call. So that's my next question, is what's on that card? What could be on that card? And maybe there's a way to get referrals to nonprofits that find lawyers for people. Or maybe we should be looking at, I know the budget's a problem, a fund like Mayor Wu is doing in Boston for people that many of them are indigent, and there's no right to counsel for an indigent in ICE proceedings. And the last one was, and this one is even more complicated, and I did talk to Superintendent Campbell about it. As I looked at the videos in Minneapolis, and I doubt that anyone's looked at them more than I have, but maybe you have, it seems to me that one question that came to my mind is, were there any local cops present? I don't know if they were or they weren't, and I'm not saying the duty to intervene is a simple thing. And by the way, I think paragraph 6 is, it's just a resolution, but I think it's, the first sentence is, the first part of it seems superfluous, duplicative, and the second part misstates the general order, which is more than investigate. But anyway, the point is, what I asked Superintendent Campbell about, and he alerted me that it's very complicated. Why doesn't ICE have to notify local municipalities when they know they're targeting somebody, looking for them at work or home? It seems to me that just having local officers present would be a deterrent to some of the brutal stuff that we're seeing out of ICE. So I'd like to have those things considered for possibilities as friendly amendments to the resolution. And maybe if they came out of the advisory committee, they'd be considered even friendlier. Thanks.
Thank you. Just a quick question. Have you proposed any of these to the moderator to see if those
Well, I did talk to the moderator several times about a referral for a study committee on the bylaw, and secondly, which he said was a legitimate motion if I want to make it, and leaving the proclamation in place in the meantime. And secondly, about adding some specifics to the resolution. And he said, actually, at the time, I might have been deluding myself that anything that comes from me could be considered a friendly amendment. He certainly said that the things I mentioned to him, at least 2 or 3 of the ones I mentioned, and he said, given the status of a resolution, that they sounded appropriate within the scope. If that's what you're asking.
Yeah.
And can I
Okay.
just
I just
very
wanted to get-
briefly, Susan, I'd
Yes.
love to say, Marty, I think you have some good ideas here. And I'd be curious, I'd love if you're willing to take you up on the same offer Jocelyn made, which is if you have any suggested language affecting these provisions, we'd be happy to review them and consider them as friendly amendments potentially.
Right.
Well,
And then
thank
at
you.
some point you could run them all by the moderator just to take care of that before we actually come to discuss them
Mhm.
at a future meeting.
Okay, next is Perry Grossman.
Yeah, a little simpler question, I think, is following up from my email and the agenda packet for Susan Harris and the petitioners. I'd like to know if the resolution should be submitted to a particular role, for example, the governor, rather than to a particular individual, such as Maura Healey, noting that some of these individuals, particular DA Morrissey, are likely to change. Thanks.
So I will just say on the timing of it, the DA election, my understanding is the September 1st will be the primary date, and then it'll be on the ballot in November along with the federal elections. So presuming this passes in May, it would be submitted to the Norfolk County DA's office while Morrissey is still incumbent. I think more broadly on the question of whether it should be addressed to individuals or offices, I think just based on my past experience with resolutions, they've typically that I've seen been addressed to the individuals. But I'm not sure that, we feel too strongly about it needing to be one way or the other. Yeah.
Okay.
Perry, are you all set?
Yeah, just and Joe Callan and did answer, but Susan, I'm wondering if you could clarify or make if you have a recommendation. As I
Well,
wasn't fully clear on Susan
yeah, I mean,
Harris. Sorry.
right. Susan.
Sure. I did see your email and I saw Joe's response, so I wouldn't have anything differently than what he shared. I think it could go to either, it could be addressed either way, but it seems like based on the time frame here, none of the roles named would be expecting to be changed in the very near term, which is what we're looking at for sending notifications if this were to pass.
Okay, thanks.
Okay, Neil Gordon.
Thank you. Let me weigh in on Perry's comment first. I think that we as a matter of practice ought not be asking our electeds to act in their personal capacity. That they hold particular offices, and we ought to be asking in that capacity. I appreciate the prognostication that comes out of town council's office, but who sits in the governor's chair is up to the voters. I know what button I wear, right? But I think as a matter of record for the town, we're not being asked to weigh in on that particular race. Let me make some comments regarding the resolve clauses. First, I really would like an answer to the question that I asked and Danelle asked. We in the first resolve paragraph speak to the unconstitutional acts of President Trump, his appointees, and federal agents engage in unlawful operations to attack people in Massachusetts communities on the basis of, and then it continues. That is remarkably similar subject matter that came to town meeting in the last annual town meeting, and more specifically last November. And as I said when I asked the question the first time, significant said that if this came to a public vote, they would leave. They would walk out of town meeting as to not be on the record, because there were folks who feared for their jobs, feared for their grants. I'm not sure anybody said they feared for their lives. That was not an insignificant matter, and it was an extraordinary ruling by the moderator to take what by my account was an illegal vote, right? And so my question is, what's changed in the last less than 6 months?
I think it's a fair question, Neil, but what you're really asking us to do is speculate on what has changed in the minds
Well,
of
some of the
close to 300 people.
some of your with all due respect, some of your co-petitioners are folks who threatened to walk out of the room, and so I want to know what changed. Not for town meeting, not for everybody.
And we may
for the
face similar.
petitioners. You're working as a. Let me finish.
Go ahead.
Let me finish. You stated on the record you're working as a group. Members, co-petitioners, right, had serious issue with the language, quite similar to what is in paragraph 1 of your first resolve, right? And what's changed? Or should we expect the same? It's a two-part question.
To be honest, I don't really know that we have a definitive answer for you. We've not heard, or at least I have not heard individuals express a desire for a non-public vote on these articles. That very well may arise, and we may just not have been, that may not have been surfaced to us at this point. It may come up later. We don't know. As to what has changed, again, I think that just calls to speculate on how a large number of individuals are viewing very complex topics and issues. I don't really want to offer something that.
So I would say
that
individual petitioners who are on the record of saying they would walk out should be able to answer that question.
I mean, if you're referring to myself, I can tell you the reason I said that at an advisory committee meeting in the lead up to the last town meeting was I had heard from a number of town meeting colleagues who expressed grave reservations about taking that vote at that time, given the, I think, not unwarranted concern for federal retaliation, particularly for people whose jobs were directly supported either through federal funding or indirectly through federal grants. Again, that concern may be surfaced again. We've not heard it yet, but if it is, I think that remains a valid concern.
All right, let me get some other points. As I said, if I get to second, I think the governor and so on, titles in their official capacity is what we are asking. I want to ask something specific though about the agreement, the last remaining 287G agreement, which is with the Mass Department of Corrections. So first of all, can you tell me of the representative delegation and of our state senator who you've talked to about what was at the time you submitted your resolution pending legislation and what is now legislation passed by the House and is on its way to the Senate? And, were you aware of it at the time? What conversations might you have had with the representatives and the senator, and what advice you got from them regarding the resolution?
So I can take that one. As in my day job at Mira has worked really closely with our state legislators on what I assume you mean the PROTECT Act, Neil, which passed the House.
I'm talking about the act that was recently passed by the
PROTECT
Yeah.
Act,
Mhm.
yeah, which was passed at the end of March and is now before the Senate. That does include language on the 287G, which would bar future 287G agreements, but does not force the state to withdraw from the current 287G agreement between the State Department of Corrections and ICE.
Right, and was there feedback from our delegation specifically? Were there
On our federal
conversations?
delegation or on our state,
The Brookline 4 state representatives and the state senator specifically, did the petitioners have conversations? And what was the advice of the representatives, if any, that you spoke with, if any?
I don't believe that we had specific conversations around this resolution with our delegation.
Okay, thank you. So I have a question specifically on the 287G agreement with the Mass Department of Corrections. Because most specifically, the Black and Latino Legislative Caucus, right? That's their version of the bill is what passed the House. And it specifically includes as an exception to the no agreements with ICE, that particular provision that they would like to have stay in place. And I'd like to know what the reason that the petitioners are taking a position different from the Black and Latino Legislative Caucus.
You know, oh, go ahead, Jessica.
Because
Sorry.
you're asking the, first of all, you're asking the town meeting to take a position separate from, and the Black and Latino Legislative Caucus has explained their position, which I don't have particularly handy to, or I'd quote them. And so why are we asking the town to take a position separate from the caucus? Which is the legislation that was passed by the House.
So, you know, I can't speak to their specific rationale. I'd be curious to learn more about what their thinking was there. I can tell you that from the petitioner's perspective, and this is a conversation similar to the conversation we had with the select board, comes from the fact that what has become very apparent over certainly the last 15 months is the fact that if we believe in humane treatment of people in detention, if we believe in the Eighth Amendment and people's right to avoid cruel and unusual punishment, then in good conscience, we as a state cannot continue to turn people over from the Department of Corrections to ICE. There have been over, I think it's now 40 recorded deaths in ICE custody in the last 15 months, far outpacing similar.
No, I get it.
Well, that's why.
I'm not suggesting that I'm a big ICE fan here. You know that.
No, I don't think you are, but I'm just telling you that our rationale was we're a state that believes in the Constitution. We're a state that believes in due process. And what's become abundantly clear from our perspective and from the data that's out there publicly is that turning people detained in Massachusetts over to ICE can reasonably be foreseen to be violating their civil rights down the road. And we don't believe that's the values of our state. It's not the values of our town. And we don't think it should be a practice that continues as long as the immigration authorities continue to operate in this rogue, reckless, and I'd argue illegal manner.
I will also say that in crafting our own town provisions regarding, not cooperating with ICE, we didn't create carve-outs, right? We didn't say except for this category of people, in which case it's okay to turn them over to ICE. We just, stated a value and stuck with it, right? And so we're going to apply that rule to everyone, and the same should be around 287G agreements. Why apply it to one?
So I hear. I think my overarching is that we have a resolution that you propose go to the floor of town meeting. It makes no mention whatsoever of real bills that have been introduced, that have been through committee debated. One of them passed the House, right? It's going to the Senate, and the resolution that's going to town meeting is devoid of any of that in the whereas clauses or otherwise. And I think that, yet again, we're going to send a resolution to Beacon Hill, and it's like, here comes Brookline again. Because I've had a conversation with the reps, and it's like, we've heard this before. Here comes Brookline again.
And we will come again and again. I don't have a problem with
So
that.
we don't,
I'm
I'm not troubled by coming again and again. They roll their eyes for a reason, Jessica.
Well, I think what I would say to that is that advocates have long advocated for an end to all 287G agreements in the state. The fact that we have this current bill, which has passed the House and hopefully will pass the Senate, it is a wonderful step. And even if the PROTECT Act passed, I think we would still want to call on the state to end
that troubles me not, right? And my comment really relates to a resident who are asking town meeting to ask of the governor's different. It's hard to call the governor and have the governor call you back. That's not true of our reps and it's not true of our senator. And to bring asking the legislature to do something when the petitioners have not had a conversation with those particular legislators, seems to me, I don't know, I don't know. I don't need to put a word to it.
Thank you, Neil. Do you have any other points that you want to bring out at this time?
No, only that I appreciate Jocelyn's comment, and you know, we're a finance committee, but and by bylaw and state law, we're obligated beyond just being a finance committee. We are an advisory committee. We need to report and take a position. It doesn't have to be a yes or no recommendation on every municipal question. That said, I think it's appropriate for the advisory committee to weigh in. We review and we vet and are presumably better informed. I take the position that some of us may be smarter than town meeting, but the advisory committee as a whole is not smarter than town meeting, and it's not our role to be smarter than, it's only that we tend to be better informed.
Thank you, Neil.
That's a different, the line's drawn in a different place.
Okay, Marissa, you were next on the chat list and then you said to skip you.
She withdrew her comment.
Are you sure?
You sure? Marissa?
Well, she may have had to step away.
Okay.
There's nobody else in the chat. I will ask a question at this point. In one of the whereases regarding BRIC, it says that 97.7% of the people in its database being people of color. Can you cite a source and how that information was, how we got that information?
I can pull up the report. I would need a couple of minutes, but I can drop that in the chat.
Just
And
wondering, it doesn't seem like they're going to be putting it on the internet for all to see. It seems like that database would be privileged in some ways. How do we know that's accurate?
yeah, there have been reports that have been done by the ACLU and others following Freedom of Information Act requests that I believe that specific data point was drawn from. Fatima might have more to say on that, but I know that we pulled that from a reputable source, which I'm happy to share.
So, yeah, if you had citations, that would be really helpful.
I'm going to jump in there.
If I could answer,
Absolutely.
we were part of that
Please.
lawsuit, and we won that lawsuit against the city of Boston. So the Muslim Justice League, the ACLU, and a handful of other organizations sued the city of Boston to get the gang database records. And that was the ACLU's analysis that produced those numbers. It's on our website. I would have to find where it is on their website as well. The city of Boston has now removed, I think, maybe 1,000 or so people, but that wouldn't change that percentage, very much, given the total of number of people that were in it. But that was based on a lawsuit that was a Freedom of Information Act or a public records request, and the analysis done by the ACLU of Massachusetts.
Okay, thank you. That was
Thank
very-
you. Could you provide the citation for that lawsuit? Or could
Yes,
someone
yeah.
provide the citation?
We can make sure you get that after the meeting.
Yes, yeah.
Yeah, thank you very much. Next up is Superintendent Campbell.
Thank you. I just want to throw in a couple of comments. I guess I want to make sure that when we're talking about this, that we all know what we're talking about and we have accurate information. There have been a couple of things said tonight that didn't seem quite quite right. During the initial proposal, there was a comment about people being fingerprinted and that there are people fingerprinted regardless of whether or not charges are brought. And this is simply untrue. I've been doing this for 27 years. We've never fingerprinted anybody, to my knowledge, where charges were not brought. So when people are fingerprinted, it's because they're in custody under arrest and being charged. Just a couple of comments about the BRIC. The idea of us withdrawing from the BRIC, pulling back. There was a comment that the petitioners are confident the department has the ability. I forget exactly what was said, but essentially to fill the void, to disseminate information, and to pick up the slack that would be lost from the BRIC. Again, it's simply not correct. The BRIC has a staff of analysts that they have a team that synthesizes and analyzes information. I recognize there are concerns here about that information and how some of it may be accessed by agencies that we don't want to have access and what the information may be used for. But let's not misunderstand what we're talking about here. If the BRIC is gone, we don't have a way of picking up that slack. I mean, it's just not even close. We don't have the staff to support what they do, and we don't have the funding to increase the staff. I mean, we all know the budget situation in town. I mean, people are being asked to do more with less all the time. We just wouldn't be able to pick up, what we would lose. I do also, I don't know how the politics factor into this in Boston. I do look at the mayor in Boston, Michelle Wu. She is in a position to have a direct impact over the BRIC and whether or not it exists and to what extent that it exists. I think I assume we're all pretty much in agreement that she's in alignment with a lot of these policies, and yet she doesn't shut down the BRIC. And I do think that should tell us something about the value that the BRIC brings. And maybe it's not something that we want to just abandon. I have a couple of notes here. There was a comment about information. This also related to the BRIC, I think, but about information being shared about people who are not convicted of a crime. I have no doubt that that's correct, but I would just also caution the fact that a person has not been convicted of a crime does not mean that there isn't intel related to that person that might be valuable to law enforcement, does not mean that there shouldn't be sharing of information in certain circumstances. And I agree that there should be, parameters surrounding what we do and don't share. And I agree, we don't want to be surveilling people, just because they're exercising First Amendment rights. But conviction is not the standard that I don't think any of us want to abide by. Just a comment about the fingerprinting. The chief told you a little bit about my story. That goes back quite a few years. Someone tried to kill me. And he said that he was 17 years old. And I remember at the time thinking to myself, he said 17, I would have believed 15 because he looked young. He knew he was wanted for murder. He didn't carry identification on him for that specific purpose, so that he could not be identified. And the way we positively identified him was through fingerprints. That was the only way to positively identify him. I jotted down a list of some crimes that would be impacted by the resolution that I think is worth considering. There might be a perception that because a crime is a misdemeanor as opposed to a felony, that it's a minor crime, or because someone is a juvenile, that we're talking about minor offenses. The stats, I believe, last year were that we arrested 3 juveniles. That's probably around average for what our department does. We divert cases whenever possible. Of the 3 juveniles that we arrested, one of them was for possession of a firearm, and one of them was a person who told us he was 18, and in fact, he was a juvenile, and we didn't learn until he was booked that he was under 18, that he was a juvenile, but excuse me, I just want to give a short list of some crimes that we're talking about that are implicated by this resolution if it were to pass. Drunk driving, disorderly conduct, domestic assault and battery in a police officer, firefighter, or an EMT, resisting arrest, driving to endanger, indecent exposure, criminal harassment, sex for a fee, possession of cocaine, heroin, methamphetamine, secretly recording a sexual video, revenge porn, a minor who commits a rape, armed robbery, murder, home invasion, kidnapping. All of those crimes are crimes that would fall within the parameters of this resolution. In my opinion, I mean, I'm just one voice, but in my opinion, these are people we want fingerprinted. These are people we want to know for certain who they are. And I just wonder, I understand the sentiment of the resolution. I just wonder if the resolution itself, the way it's crafted, it just doesn't narrowly exclude the things that I think we can all agree should be excluded, but while still including the things that really need to be included. So anyway, those are my comments. Thank you.
Thank you.
Thank you. Next up is Russell O'Neill.
Thank you. I think the superintendent really just kind of hit everything, but just specifically, I wanted to touch on the BRIC data because the site or the source was just put in. I haven't been able to review the whole article, but I was shocked to see or hear 97% of the BRICS database. That seemed like I found that number hard to believe. And so seeing or hearing that it's from the gang database, I think is a little bit misrepresented in the Warrant article as written. It doesn't specify that. And, you know, to my knowledge, working on the police department, we really don't utilize the BRICS gang database to the best of my knowledge. I'm sure we have at some point, but you know, most of our interaction with the BRIC is for things like auto theft, crime trends, things of that nature. So I think it misrepresents the data as it's written currently. Thank you.
Thank you. Okay, there's nobody else in the chat, so I'll just make a few quick comments while I have the opportunity. Getting rid of BRIC seems to be cutting off your nose to spite your face. The list of serious crimes that we've heard of seems to be a reason to keep this. It doesn't change BRIC's operation at all if we withdraw. If we withdraw, BRIC continues exactly the same as it was before, but we lose a whole lot of intelligence to find actual criminals that we need to find. And if memory serves, and I might be wrong on this, but when John Salvi opened fire in 2 health clinics in Brookline and killed 2 people, and he fled the state. If I recall correctly, when he was arrested, he gave a false name, and he was eventually identified through fingerprints. But I mean, that was a long time ago, but I remember it vividly because I was on the same road that he was as he was fleeing. I remember that. So having real criminals who need to be identified, who may give false information, I think outweighs the idea that we should get out of BRIC. And if getting out of BRIC is not going to change BRIC in any way, to me, that it's just a nonsensical solution because it doesn't change anything, and we need that data. As far as UASI goes, I think that's also fundamentally flawed as a concept. Shows you really don't understand how UASI works. A judge actually stopped that some of that money needs to go to ICE part, so that's not in place currently. The amount of stuff that we have gotten from ICE, it's not armored vehicles, it's not weapons of war or anything. It's radios, it's training for firefighters and police officers. It does a lot of good in this town, and to get rid of it, again, makes no sense. And if we don't take that money that's offered to us, one of the other communities in Uwasi is going to say, yeah, we'll take it. They'll take the money that should have come to us, and no behavior in Uwasi or anything else will be changed either. It'll continue on if we withdraw. Withdrawing is not a solution. It doesn't do anything except hurt us. It doesn't make a statement. It doesn't have anybody at Brick saying, you know, Brookline just withdrew. Maybe we should rethink what we're doing. Of course not. That's not going to happen. So I don't see any point to a number of these things that will hurt our ability to find serious criminals. And Uwasi, which gives us badly needed training and equipment for our public safety people. It's just, it makes no sense to me. So if we do vote on this tonight, I'll be making amendments to delete those therefore resolved parts and the last whereas, which involves Uwasi. I do appreciate the sentiment. As I said before, earlier tonight, this is personal for me. I happen to have a relative who's in the country illegally. She overstayed her visa. Last I heard, she was in Indiana, but that was years ago. She could have moved. She could have been nabbed by ICE and returned to Venezuela. I don't know. I'm out of contact with her, but I am concerned because she's a very nice person. And so this is personal for me. ICE, you know, is completely out of control. And there have to be better ways to stop them and make sure that they follow the law that all the other law enforcement agencies in Massachusetts go. But some of these things, when I'm looking over this resolution, while I appreciate the sentiment, where I appreciate where it's coming from, it seems more of a political statement than a policy statement. And I think that when you're talking about a municipal government taking a stand or making decisions, it should be more policy based rather than emotionally based or politically based. So I am troubled by the wording of this, and I'm sure there'll be other amendments as well, but you know, I do appreciate it. So those are my comments. And Susan, oh, hold on, 3 people have just come in. No, I think they already spoke. All right, scratch that. The chat is
If I
clear.
can just briefly respond to that, I would just say, you know, I think just like with 17, you know, we already anticipate some amendment suggestions from members of the committee tonight. And I guess maybe my hope is we may hold off on a final vote on this one because I think we will likely want to incorporate, you know, a good deal of this feedback. And certainly, David, Mark, if there are specific language suggestions or concerns that you'd want to share before that vote's taken, we would welcome that. And
I'll send this to you. Thank you for
really
that.
appreciate that. Thank you.
Okay, Susan, there's nobody in the chat right now.
Okay. Do any of the other subcommittee members want to say anything at this time? Particularly people who haven't said anything to this point about warrant article 25.
We
I haven't,
at this for an hour.
right. I haven't
So we have
spoken,
4 hours to go.
right. I haven't spoken up about this, so I'm gonna, but I know it's late, so I'm just going to say that I share David Mark's perception about this. I'm very concerned that even though this is a resolution, that I feel that town meeting members are so angry and upset at what is happening with ICE that they may very well vote for a lot of things without from an emotional point of view, without appreciating the public safety consequences to the town of having the select board do exactly what this resolution requests. Now, it's possible that it could pass and it needn't be followed word for word, but the thinking is if we ask for it, if town meeting passes a resolution that expressly asks for certain actions, that they shouldn't be voting for it if they don't want those actions to actually take place. So we have to be careful, even in a resolution, that what we're asking for does not endanger the town because of inadvertent consequences. And so I think that more thought needs to be given about specifically the resolution resolve clauses 4, 5, 6, and 7. And maybe not 6 so much, but definitely 4, 5, and 7. And I think that needs to be given a great deal of consideration. And because I think that whatever we ask town meeting to do, it should be based on the assumption that these actions will actually take place and not simply be performative or making a statement, because we believe what is being written should be an action that we support. That's what the basis of the resolution is. So anyway, I think that based on everything that people have said, we certainly are not prepared to take any votes on the current versions of either 17 or 25. There definitely will be a follow-up public meeting on these. The date to be determined in part by what we're told from petitioners, but we don't want to delay this excessively, because the result will be that we will not be able to get reports or varied revised versions to town meeting without doing it at the very, very last minute. And we'd like to avoid that as much as possible. So hopefully we can have a meeting within at least, say, 2 weeks from now, if possible. And so let's try to do it somewhere in that time frame. And again, the final report to the AC is on the very last day that the AC is holding regular meetings this spring, and that's on April 30th. So let's work backwards from that. But let's
Susan?
assume that we'll need at least one more meeting and possibly even 2. And so we need to make certain that we allow for that.
Okay, Susan, there are two people in the chat, Perry
Oh,
and
okay.
Perry?
Yeah, so I put some language in there, and again, this is so mundane compared to the bigger issues being discussed here, but I just suggested striking the names, and I don't know if I have the language totally right here, but just saying to the governor, lieutenant governor, attorney general, Norfolk County District Attorney, Brookline Select Board, and the Brookline Police Chief.
And I will be adding that language to the draft because I agree with it.
But we're really going to ask the town clerk to send a copy of the resolution to the select board? Really?
Well, Neil, we can fiddle with that.
It's like we might be able to leave them off, presuming
Right.
they'll be in the room for the debate.
Right.
And the police chief.
I'm sure there are going to be opportunities for us to look at the next stage of the wording and weigh in on what the next version of these articles are. And I think sometimes it helps if you have an opportunity to actually see everything that we're talked about laid out in writing. And that helps us, I think, to focus on what is left to be done at that point. Okay. Is there
Liz
are there
Linder's
any other
next.
comments at
Yes,
this
I
point?
just said so. Liz Linder's next.
Yeah.
Oh, okay.
Thank you. Just very briefly, this is also personal to me. I employ an immigrant and have been basically sheltering her for a number of years, and she's been doing great work for me. But it's, every year, we have a fork in the road to look at. So, but because this is so emotional, so I 100% support the sentiment and what's behind this, but it seems right now, I'm just, there've been a lot of comments that I don't need to go back into. There's problematic unintended consequences that really actually work against the spirit of the article. And so I'm looking forward to seeing the language cleaned up.
Okay, well, thank you. I think people have really, what?
Fran, do you want to comment? You said in the chat that you were too busy, but this would be a good time.
She's our note taker for the meeting.
Okay.
I don't envy that task, but
Nobody
And
does.
Susan, if I can just very, very briefly, just
I
to
think
wrap
I
up.
have 10 pages of notes.
okay. I'm sorry, who asked that?
That was Alec. I just wanted to say, just in closing here, that I think we're really appreciative of the conversation this evening. I heard a lot of suggestions that I like, and I think you've given us a lot to work with. And in particular, I just want to thank all the town staff, Chief Pastor, Chief Sullivan, Superintendent Campbell, Susan Harris. I think we all know how difficult the jobs that you all do are, and I think it's just a terrible situation that we're in, that the federal government seems determined to make it even harder. So I think we want to end on articles that everyone can support. I think the community is united on this issue, and so I just wanted to say we're very appreciative of the feedback, and the tenor of the conversation tonight, frankly, and we're looking forward to coming back, with updates made accordingly. So thank you all.
Okay, thank you. So if you could submit the PDFs of the visuals that were used in the presentations, we'll have that for whoever winds up writing the reports on these, and it would help just to summarize the main points that you made for people who would just like to be informed of your presentation. Okay, so the next step.
Wait a
will
second,
be...
Susan, may I
Yes.
jump in?
Sure.
Besides the visuals, don't forget to send all those documents that you were talking about.
Yes.
Yep,
Absolutely.
we'll get you the
I mentioned
report,
that earlier. Please
both
see-
slide decks. Yeah.
Yeah, please CC me and Fran on the suggested changes. It's not something at this point that we need to post as far as Lisa is concerned, because it's not something that we had during the meeting, but it's something that it will be helpful to have at a future. We may want to post that at the future AC meeting, perhaps, or related to our next meetings. But at any rate, at this point, it's helpful if you could just make certain that in addition to sending it to, who should they be sending it to as far as the main petitioner, Alec?
So you can send that to myself or Chi-Chi, and we can ensure that everyone's, gets that.
Okay.
Can I ask also that Jessica and Fatima, if you can email me or Susan with your titles or your background, or if you
and the
your
organization,
association, so we could add that to the minutes.
Yes, and this is also a good time to note that I believe you may be using the wrong email for me, Susan, in some of the emails that have been circulated in advance of this meeting. I didn't get them. Other petitioners forwarded to me. So I just wanted to flag that. I'm happy to.
Could you put
right, we were sent two different ones for you, and
could you put the one you prefer in the chat right now?
Yeah, it's just first name dot last name at Gmail, but I'll go ahead and do that. Thank you so much.
Yeah, that was the second one that we got. So yes. And okay. And what was, oh yes, and when would you like to receive the wording suggestions, Alec?
I'd say whenever people have them ready, please send them over, because that just gives us time with it.
Now, town meeting, the select board is meeting tomorrow night, correct? Would you prefer to get changes by then, or are you not going to need them until after the select board meets?
So it would be probably ideal to get them before that, but given the fact that the turnaround for that will be extremely tight, and seeing as it's already 9 p.m. tonight, and that doesn't give people a lot of time tomorrow, I think we'll certainly have another conversation with the select board tomorrow night. I anticipate they'll have changes they want to see made as well. So I'd say if people can't get that to us before, tomorrow evening, I wouldn't sweat that. We're going to need to, I think, come together after the select board meeting and synthesize, a number of these proposals. So anytime, I'd say next week would be great. But sooner, just gives us more time to consider. So that would be appreciated.
Okay, thank you. Okay, so it is 9:50 and
8:50. It just feels like 9:50.
oh, it is, yes, it's 8:50. Why? You're right, it does feel like 9:50. Okay, so the public hearing is officially over, and our meeting will be continued at some date to be determined, but we don't know yet.
So is it a continuation of this public hearing or is it a separate meeting?
Well, the public hearing, I think, it has been concluded, but we will be having a public meeting. And this is, I mean, this was both a public hearing and a public meeting. I just never closed the public hearing portion of it.
Although, Susan, the public might be interested in commenting on any proposed amendments. Leaving that up to you.
Right. No, have we ever continued a public hearing to another?
I have no problem with doing that.
Okay, let's do that then. I'll just keep it open then.
Yeah.
And so to be determined a date in the future, but hopefully within the next 2 weeks, because when is the 30th? I mean, actually, we need it sooner than 2 weeks, or else there won't be any reports on the 30th.
2 weeks from today is the 21st.
Is
right?
the 21st?
No, 20th.
Oh, okay. That would
20th.
be, I think that should definitely be a point that we aim for, to have a meeting by that time, because again, if we need a follow-up meeting, it's going to be keeping things really close at that point.
Yeah, I will try to get us availability for the petitioners for the next 2 weeks.
Right.
So that,
and I do know that I believe the police chief is not available that week. So hopefully Chief Pastor, the week of the 20th, the 21st is a week that you're not going to be available.
That is correct. We have the marathon on the 20th, the following, shortly after that, it's school vacation week.
So, Susan, I can send my comments to Chief Pastor as well, and if she could certainly respond in writing.
So let's try to keep Chief Pastor in the loop of wording changes. We should definitely include her as one of the CCs for those.
And we're happy to do that as well as we, consider the various changes. So we'll make sure.
Right. And as well as I think Chief Sullivan and Associate Town Council Susan Harris, just so we get everyone's advice about aspects while it's still in the writing stage. Okay. Well, thank you all. This has definitely been almost a marathon in preparation for future marathons. But thank you all for your patience and attention and participation. I think this was a really great turnout, and I think we've all learned a lot. So thank you all.